are we are continuing chapter 6 this morning. We left off. Last thing we did was doing the notes here, highlighting for dower and courtesy. Did everybody get these on page 105 and 106? Dower and courtesy stuff. I know we had a previous slide that did the explanations of it, and then here's where we did the highlights in the book. Okay. Yes. All right. So, encumbrances. What is an encumbrance? It's some sort of a burden, right? So without even knowing or going over the types of burdens on real estate, if a property is burdened by something, remember I gave you the example, if I jump on your back, you're burdened by my weight. Can you still move around? Yeah, it's just a lot harder to. So if real estate is burdened by something, we didn't even go over the types of real estate encumbrances yet, but if real estate's encumbered by something, can you move it? Sell it? Yes, it's just a lot harder to. It could affect its value and saleability. So an encumbrance is a burden on the property. Claims, liens, charges, or liabilities attached to and binding on the real property that could limit its value or title. Liens are a financial claim against real estate. We have mortgage liens, tax liens, lawsuit judgments, which can become liens against the property, mechanics liens, which are unpaid contractors who haven't been paid. They can put a lien on the property as well. And we have physical or usage encumbrances as well. These include deed restrictions, easements, licenses, and encroachments. Here's a little brain teaser for you. All liens are encumbrances, but not all encumbrances are liens. Right? Well, that's true, because if we translate it in our head, a lien is a financial claim against real estate. So all financial claims are burdens, but not all burdens are financial. Right? That's how we, when we translate it like that in our head, it makes it a lot easier to understand that sentence, right? All liens are encumbrances, but not all encumbrances are liens, you know? So let's do a highlight here of that liens are financial claims on property, and there are physical and usage encumbrances as well, including restrictions, easements, encroachments, and licenses.
One quick question. Can you just explain in layman terms? It says encumbrances are a burden, and then the financial liens. They're the same, but not really the same.
Well, liens are financial claims on property, but there could be physical or usage encumbrances as well. So liens are financial burdens, but there could be physical or usage encumbrances, physical or usage burdens on the property. You know, like restrictions in your deed on how you could use it. Okay. Easements, which gives someone else the right to walk over your property or use it for a reason. License would be a temporary permission, and encroachments, like if your neighbor builds something over the property line. Those are physical or usage encumbrances. And it's funny because I was just looking at and considering adding one of these little shorts, one of these video shorts there that was talking about those types of encumbrances. Once again, it was that real estate lady. She had it from one of those judge programs here. You guys seen these programs on TV, right? You know her, right? This lady. She's the judge, one of these TV judges. So over here, there's a problem with the neighbor.
You have to understand something. She owns a property. If she says you gotta get out, you gotta get out. You gotta take all your toys with you.
What would you do if your neighbors built a chicken coop and a tool shed in your backyard? This exact thing happened to a woman on People's Court.
What were the two buildings that were fully on your property?
I do have pictures here. One of them is
What's all that noise? Hold on a second. Let me mute everybody. There's some noise coming from somewhere. Let's back this up a bit.
Neighbors built a chicken coop and a tool shed in your backyard. This exact thing happened to a woman on People's Court.
What were the two buildings that were fully on your property?
I do have pictures here. One of them is a chicken coop. They have free-range chickens. And then the defendant said, oh, I built that big stone fire pit.
In North Carolina, this is called an encroachment. When someone
That's what it's called everywhere. She's a North Carolina attorney. That's why she's always saying North Carolina.
build something on your property. And to resolve it, one, removal of the encroachment. Another thing is an encroachment agreement that allows that particular structure to remain in place. And sometimes you have to sue to get the encroachment removed.
She's still complaining about the buildings, and
Well,
she
she's
said
complaining
do
that you
this
have
and
this
do
kind of
that.
junk on her property.
The desk is not mine.
Whose desk is this?
The neighbors.
Okay. All right. So whatever. So as you can see, there could be physical or usage encumbrances. That's a physical encumbrance where somebody is encroaching onto your territory, building a chicken coop and a shed on your property. So not all encumbrances are financial in nature. That's what that means. Okay. Liens are financial claims. Once again, here we could highlight it. Liens are financial claims on property that provide security for a debt or obligation of the property owner. If the obligation is not repaid, the lien holder or creditor has the right to have it paid out of the property. So even though liens attach to properties, they pass on from one owner to the next because they follow the property, not the owner. So this is why it's very important when you're buying a property to do a title search to make sure there's no liens or encumbrances on a property. A lien is a financial claim or encumbrance on a property. So we need to find out if there are any liens on the property, and we're going to want that seller to clear them up before the buyer goes through with the purchase, because the liens pass along with the property. They run with the land. So if you buy that property is responsible for paying back the lien. Maybe you as the new owner are not personally responsible for paying it back, but if you want to keep that property, you are. Because the property could be forced to pay it back through a process known as foreclosure. Okay, it's nothing personal against you. It's against the property because the property has the lien on it. You should have done your due diligence and did a title search before you bought it. All right. So liens are classified as voluntary or involuntary and general or specific. A voluntary lien is something you wanted, you went out of your way to get, like a mortgage loan to buy the property, right? Or involuntary liens. These are ones that are imposed on you. Nobody wants them, but you still got to pay them, like taxes, right? And liens can be general or specific. A general lien, remember I said anytime in general, it's a wider scope. It's a lien that affects all property you own, including your personal property, where specific lien only affects one parcel of real estate, where general liens can affect more than one parcel of real estate or even your personal property. So voluntary or involuntary, general or specific liens. You guys have the understanding of them, or anybody need a clarification on that? Okay. So
a voluntary.
Yep. A voluntary lien is created by the property owner. So you went out of your way to create it. It's one that you wanted. Like a mortgage loan, right? You filled out an application, you submitted your social security number so that they could do a credit check on you. You maybe even paid an application fee and appraisal fees and um, down payments and all kinds of stuff. You submitted your tax returns, your pay stubs, your bank statements. You went out of your way to get that, right?
Okay.
So
Okay.
it was created by you, the property owner. That's
Okay.
what's
Okay.
voluntary. Voluntary is something that you did willingly. You wanted
Okay.
it. Involuntary, something you did not create. You don't want to pay, but you have to, like your property taxes, right? Those liens are imposed on you. You don't have a choice. You have to pay them. Okay. So the involuntary lien is imposed without the owner's consent, like property taxes. All right. A general lien affects all property someone owns, and specific lien is placed against one parcel of real estate only. So there we go. We got our highlights there for the definitions of everything in the book on page 106. Everybody got that?
Yes.
No questions. Everybody understand everything here? Pretty straightforward, right?
Now I do. Yes.
Okay, so just another slide about liens. They're a voluntary lien is created by the owner, involuntary without the owner's consent. General liens affect all property you own, real and personal property, and specific liens only affect one parcel of real estate only. Some examples of specific liens would be if you don't pay your utility bills. Special assessment liens. A special assessment is a tax by the municipality so that they could do improvements in the area where your home is. Ad valorem tax, that's your general real estate tax that everybody pays, their property taxes. They call it ad valorem. It is Latin. It means according to value, because that tax is based on the value of your home, in part. Mortgage liens, they only affect the one property. You don't pay it, they could only touch your one property. They can't touch any other properties you own or any personal property. Same thing with a contractor's lien or a vendor's lien. I'm not sure what they're talking about there, but okay, let's say a vendor's lien. Now, general liens, sorry?
What's a vendor's lien?
I don't know. I don't know what they're talking about there, vendor's lien. So general liens, they could be judgments. You had a lawsuit judgment against you. Someone can go after all the property you own, right? They can put liens on your car, your house, your bank account. You owe them money, right? You got a judgment. They could turn that a lien against anything. Estate and inheritance taxes, deceased person's debts, corporate franchise tax, and IRS taxes. They affect all the property you own. So those are general liens. So what are the effects of liens on your title, your ownership? Well, like I said, liens attached to properties, not to property owners. So the owner's still free to sell it to someone. You could sell a property with liens on it if someone's willing to take on that encumbrance along with the property. Would you be willing to buy a property that has a $50,000 lien on it?
It depends on the value or what I intend to do with the property. Like if
So is the
it's
juice worth the squeeze for you, right?
yes.
So if you get the property at a good enough price to make up for that $50,000 lien, then it may be worth it. Or if you really need that property for an overall plan, because maybe you bought some properties around it too, and you need that one to fit in. Or maybe it's of extra value for some reason, because maybe you have some privileged information that you know that there's some gold or minerals or oil or something on that property, right? Or you know that Amazon's going to want to buy it so they could put it in their huge warehouse. Something like that. Yeah. So encumbrances, liens and other kinds, they do run with the land. They pass from one owner to the next, and they're still binding on the property even after the sale. So do your due diligence and do a title search to find out if there are any liens on the property before going through with the purchase. Now, most liens are wiped out due to foreclosure. If your property gets foreclosed on, most liens get wiped out. All liens get wiped out for tax foreclosures, But a regular mortgage loan foreclosure does not wipe out tax liens. It could wipe out other liens if there's not enough proceeds from the sale at auction to pay them off, though. Liens attached to properties, not the property owner, once again. So you, as a property owner, are not personally responsible for paying the lien, but the property that you own is. And the property could be taken and sold through foreclosure so that the lien can be paid back if you do not pay it back. So there we go. Here's an interesting note I put about foreclosure. Taxes get paid first because two things are certain in life: death and taxes. All right. Well, even after foreclosure, if you buy a property at foreclosure auction, you may still be responsible for any tax liens that are outstanding on it. Taxes always get paid. So taxes get paid off first in the event of foreclosure sale. If any money is left over, liens get paid back in the order in which they were recorded in the public record until there's no money left, and then any other liens that may be left over get wiped out. That's what they mean by liens do not survive foreclosure. They don't just get wiped out, they get paid back in the order in which they were recorded in the public record until there's not enough money left to pay them back, and then they get wiped out. This is, of course, with the exception of tax foreclosures due to non-payment of property taxes. If that's the case, tax foreclosures wipe out all liens, even a first mortgage loan, and they don't get paid. They just get wiped out. So it's much safer buying a property at a tax auction than it is at a regular sheriff's sale for being foreclosed because you didn't pay your mortgage. Okay, because there could still be unpaid tax liens on there, mechanics liens, etc., which still need to be paid.
Now, mortgages get wiped out, not taxes.
If it's a tax foreclosure, yeah, taxes never get wiped out. Taxes must be paid always. So, but if you're getting foreclosed on, not because you didn't make your mortgage payment, but because you didn't pay your taxes, your property taxes, nothing gets paid back but the taxes. So whoever buys your property at a tax foreclosure auction, they get your property free and clear for just whatever they paid in outstanding taxes that was owed.
Okay, so you said mortgages get wiped out, not taxes.
Mortgage loans, if it's a tax foreclosure sale, all liens will get wiped out. So the investor comes in, they just pay the outstanding taxes. Everything else, any other lien on the property gets wiped out. You get that property free and clear.
Okay.
Okay. But there's a process to that, and we're going to go over it in detail. I'm going to explain it to you in chapter 8 when we talk about taxes.
Okay. Thank you.
Okay. You're welcome. So, in some cases, if a property owner, during foreclosure, in some cases, if a property owner is in danger of foreclosure, if they were to sell their property, which had a lot of equity in it, they could pay off all their debts and still walk away with a nice profit and keep their credit in good standing. However, sometimes when people fall on hard times, they let the problems try to sort themselves out. Then they get foreclosed on, and if there are enough proceeds to pay off the debts, then the homeowner will still get the remaining money back. However, if they sold it on their own, they could have gotten more in the sale than what you get paid at an auction for the property. I mean, why do people go to auctions? Any auction. Why do people go to auctions? To get a deal on something.
Yeah.
Right? To pay less to get a deal. So if a house gets sold at an auction, somebody's getting a deal. You're not selling it for top dollar. So for example, what's the point I'm trying to make here is if you have a property owner and you have your house mostly paid off, say you owe $10,000 left on your $500,000 home, right? You only owe $10,000. but you lose your job and you're unable to make those mortgage payments, you get foreclosed on still, even though you only owe $10,000 because the lender wants their money still, and you stop making payments. So what you could have done is taken out a home equity loan and paid off the house, and then use that home equity line of credit at a much lower interest rate and have more time to pay it back. You could have played around with that. Equity is your built-in value in that house, so you could have taken a loan off on that or borrowed money from somebody to pay it off, but you didn't. So you owe $10,000 on that house. So you paid the majority of it off. You could still get foreclosed on, and then it'll get sold at auction. So that $500,000 home, instead of selling for $500,000 like you could have if you put it on the market, it gets sold at auction at a fire sale price, maybe 100, 150, 200,000 less, right? If you sold it on your own, you could have gotten more for it. But you're better off if you want to keep the home, just take out a home equity loan with all that equity. You could have taken out a home equity loan and paid off the mortgage, your main mortgage, and then just had this new equity loan that you pay back slowly in smaller amounts. That makes it more affordable to do. So these are workarounds to avoid foreclosure if you have a lot of equity in the property. Okay. All right. Encumbrances, liens, and otherwise, they run with the land for the 19th time. Liens attached to the property, not the property owner. And real estate taxes have claims against the proceeds of such sale. Right? Two things certain in life: death and taxes get paid back first. So liens are voluntary. You got a mortgage loan, a home equity line of credit. These are voluntary specific liens against one parcel. Involuntary liens are ones you don't want, like real estate taxes, which are specific liens. Unpaid federal income taxes, those are involuntary general liens. Lawsuit judgments, those are general liens. Unpaid child support, those are general liens. They're against all property, even personal property. So when you pay off your mortgage loan on your house, do the liens get removed from the public record?
Say it one more time. I'm sorry.
When you pay off your mortgage loan on your house, does that lien, because a mortgage loan creates a lien in the public records against your property. When you pay it off, does the lien get removed from the public records?
Yes.
Once something's added to the public records, it's there forever. What they'll do is they'll add another document to the public records saying that you satisfied the lien and paid it off. Right. This way, if somebody in the future ever wants to do some research, if a lien were removed from the public records, nobody would be able to tell that it was ever there.
Oh, right. Okay. I understand the question now. So okay. The fact that you, the balance is not showing that you owe it, but the original
no. I'm saying when you pay it off, there is no balance.
Right.
Zero balance. You paid it off.
Right. But so, the fact that whatever you borrowed or whatever the lien was. So what I'm learning right now, excuse me, what I'm learning right now in class is the actual meaning of lien. So on the consumer side, when you hear lien, it's like, ooh, that's scary. Like
somebody. It's just a financial claim,
right?
Saying that you owe money. That's it. Right. It's I mean, you take out a loan, you owe money.
Right. But when you say loan, it doesn't sound scary because you know that you owe it because you borrowed it. When you say lien.
Yeah, you think of foreclosures and, financial hardships are coming. Yeah, I know. But
like somebody's going to take something.
Yeah, a lien's not a scary word. A lien is just when you owe money on something, a lien can be placed on that property until you pay it back. Okay, it puts the world on notice that if anybody has an interest in that property other than the homeowner now, if anybody has an interest in that property, they do a search of the public records, they could see there's an outstanding loan on the property. That's what a
Right.
lien does. It just lets the people know that there's an outstanding loan on the property. And it also preserves the order in case there ever is a foreclosure. Liens get paid back in the order in which they were recorded in the public record. So basically, when you first buy a house, you get a mortgage loan. That mortgage company puts a lien on your property and makes sure that they're in the first payment, first in the repayment order, so that they can get paid back first in the event there ever is a foreclosure. Okay. But once you've paid off a house, once you've paid off all the loans on it, the liens are never removed from the public record. They just add another document saying it's called a satisfaction of lien or a satisfaction letter. It basically says the loan has been satisfied. So so that anybody that searches the public records, now they can make a list of all the documents attached to that property. And they could say, oh, this person got a lien on the property. Oh, we see a satisfaction of lien. We could match those up and cross them both out. We could see that was paid off. All right. So this is the way you match up when you do when attorneys or title companies search the public records to see if you've got good, clear title. They want to make sure that all those liens have been paid off. They see there's a lien, they look for a satisfaction of lien. Oh, there's a satisfaction of lien. Okay, we could cross that one off then. And then we see whatever documents. Maybe there was a second loan on the property, a second lien. Was there a satisfaction of that lien? Oh, there was. Okay, so let's cross that one off too. And then they know if all the liens have been satisfied. Okay, that's how you could keep track of it. Anybody can search throughout history and see if there was ever liens and if they were ever paid off. They could see how many owners were on the property, if those owners all signed the deeds, or if it was only one person that signed the deed when the ownership was transferred. Or if that person is not the same person that was listed as the owner that signed the deed. Now you got to be scratching your head. Who the hell is this person? Did the other owner die and then this person maybe inherited the property? If that's the case, we need to take a look at the records to see their estate and see if they were the heir or if they were somebody named in a will to receive the property. And then we could cross that out as a possible what we call cloud on the title. Clouds, anytime you hear the term cloud on the title, think of title means ownership and a cloud hovering over your ownership. Think of a dark thunderstorm cloud hovering over your ownership of the real estate. You want to clear up any such possible problems. And you have a dark thunderstorm cloud hovering over the ownership of property. That's an indication there may be some kind of problem going on there. So you want to clear that up. So if we see that there was somebody who signed that was not listed as the purchaser or a previous owner of the property, why are they signing? That's a cloud on the title for sure. So we need to find out, did the other owner die? Is this person the sole heir or devisee that the property was left to? Or were there other children that were left the property perhaps, right? So maybe the person died and they left it to their children. Was there only one child or were there multiple children, right, that were inheriting the property? If only one of them signed and there was two, that's still a cloud on the title because we need the other person to sign off because at any point in time in the future, they could step forward and lay claim of ownership on that property. You don't want to buy a property if all the owners didn't sign off on it, right? So liens create clouds on the title until they're cleared up. Same thing, clouds on titles can be created when you don't have all the owners that signed, or somebody who signed that wasn't listed as that owner in the public records. It's a confusion that needs to be cleared up because it's a possible problem related to the ownership, the title. So that's what the term cloud on title means. Satisfaction of lien is just a document added to the public record saying that this lien had been paid off. Some examples of involuntary alienation. We have escheat, eminent domain, foreclosure, adverse possession. This just shows you what the action is to get the property, what the process is, and who's taking the property. Okay, I told you liens are paid back according to their priority. What establishes the priority of liens? The date that they're recorded in the public record. Okay, with the exception of 2 liens. You need to know this. What determines the order in which liens are repaid? The date they're recorded in the public record, with the exception of 2 types of liens. Taxes, they always jump to the head of the line. Okay? They don't go according to the date that they're recorded. Taxes must always be paid first. They jump to the head of the line always. 2 things certain in life, death and taxes. The other thing is a mechanic's lien. That's a contractor's lien. These liens go according to the dates that they're recorded, but they could be backdated. They could be backdated to the dates that the work began or the materials were delivered, whichever occurred first. Okay? So those are 2 unique liens in that way. Real estate taxes jump to the head of the line, and mechanics liens are not dependent on the date of recording. They could be retroactively backdated to the date that the work began or the materials were delivered, whichever happened first. Okay? So if you get a question on exam that says, what liens get paid back first, or how do liens get paid off? What determines what liens get paid off first? Their priority. And what establishes their priority? The date they're recorded in the public record. Yep. Except for 2 things. Taxes, which always jump to the head of the line, and a mechanic's lien, which can be retroactively backdated and jump ahead of other previously recorded liens. That is possible. So on page
So it would be
107
taxes and then mechanic liens, correct? And then everything else.
Correct. Now, mechanics liens don't necessarily jump ahead of everything else, but they could because they're not recorded yet. Let's say the contractor took their sweet time in recording the mechanics lien. So someone else recorded a lien first before the contractor. But the contractor did the work before they recorded that lien, or the materials were delivered before the other lien holder recorded the lien. They could backdate it and jump ahead of that other lien. Okay?
Thank you.
You're welcome. So those are 2 concepts you need to understand, and that liens are paid back according to their priority, and the priority is established according to the date they're recorded. Okay. Wow, you think we're hitting this enough times already? How many slides have we had on the same thing already? So liens and other encumbrances run with the land, mean they pass on from one owner to the next, and liens attached to the property, not the property owner. Priority of liens establishes the order in which liens or debts are repaid. Tax liens take priority over all other liens. Otherwise, they're repaid according to the date they're recorded in the public record, with the exception of a mechanics lien, which is priority is retroactively backdated to the date the work began or the materials were delivered, whichever happened first. Okay, this is actually a pretty good note just to study on this slide for your liens. And mortgage liens, junior liens, second loans for home improvements, judgments or decrees from a court saying that you owe someone else money. These can be turned into liens against the property. as well. Okay, but here we have a good note as to liens run with the land. They attach the property, not the property owner. Which liens get paid back first? What establishes who gets paid back first? Yada yada. Okay. So on page 108, just highlighted mortgage liens, voluntary lien. And here we can highlight about the contractor's liens. The construction lien is also known as a mechanic's lien. They become involuntary liens. And construction liens are unique in that they're retroactive to the date the work in question originally began or the materials were delivered. Like I said a bunch of times already.
Construction liens also run with the land, not the person?
All liens run with the land.
Okay.
They attach to the property, not to the property owner. Okay. Although mortgage liens, even though they attach to the property, if you don't pay back that lien, if the property, there's two parts of a mortgage. We didn't get into this till the mortgage chapters. There's two parts of a mortgage. The mortgage itself, which is a promise to pay, and the note, which is a document that lays out all the terms of the financing, how much you borrowed, the interest rate, what the monthly payments are, what are the terms of repayment. If you fail to make payments, what is the lender going to do? If you stop paying them,
they're gonna well, it's a couple things they're gonna do, but they're gonna, it's definitely gonna affect your credit, number one. But
well,
they're
hold on a
gonna,
second. Don't get too deep into that. What's the basics? How are they going to get their money back? You stop paying them,
They
what are
will
they going
take
to
the
do?
house away.
And what do we call that?
foreclosure.
Foreclosure. Foreclosure is a judicial process, has to go through the court system. The purpose of foreclosure is to seize property and sell it off to pay back debt or obligation of the property owner. Right? Now, what if the property value dropped and they're not able to get enough money from the sale at an auction to get paid back all their money? The note is what makes you personally responsible for paying out back the full amount borrowed. Okay. But the mortgage creates a lien. Liens attached to the property, not to the property owner. But even if they take the property and they sell it to get all the money, if there's not enough money proceeds from that sale, the note is what makes you personally liable for the full amount borrowed, and they could still come after you. This is why we do short sales. We negotiate with the lender that if we sell the property and you're going to get shortchanged, you're going to agree not to chase after the property owner for any balances. That's why we're the heroes. People don't think that you could do that. They don't think that they could sell their property if it's worth less than what they owe on the loans. But they can. And we could educate them on that. But that's for another chapter. So let's move on. You guys have these highlights? Yes, no. Okay.
Yes.
Oh. By the way, let me throw out a morning attendance poll before I forget. Don't want to throw it out before lunch.
Mr. Kaminsky,
Yeah.
I'm making up a class today, so I'm taking morning and afternoon ones because next week I'll be out of the country for, I think
No
we spoke
problem.
briefly about it.
Yeah, no problem.
Thank you.
Where's everybody else? Everybody else needs to answer that attendance poll there. Come on, come on, come on. Wakey, wakey. Pay attention. See, this is what happens. People don't have their cameras on. I assume they're sleeping or they're doing something else. They're not in class. I mean, it's already almost a minute and we still got people who have not answered the poll. So I usually wait 1 minute and time's up. No poll answer, no credit for class. That's the way that it works. Being generous by calling your attention to it for a whole minute, calling it. You know, for over a minute, I'm still calling it, and people still not answering the attendance poll. So do you think I should give them credit for being here? Not participating, not following the rules, no cameras on, no answering of the polls. Am I being a little bit obvious about it? Am I hiding this? No? Okay. So I'm going to end this poll right now at almost 2 minutes now. There you go. Lis pendens is what? A lis pendens is a public notice of possible future legal action against the property. That legal action being foreclosure. So when you fall behind on your mortgage loan payments, usually a month or two behind, your lender will record a document in the public records called a lis pendens. It's just a public notice of possible future legal action against the property, saying that foreclosure may be coming. That's the legal action. Because some states do not have judicial foreclosures. We do in New Jersey. Okay. Some, it just goes through a third party who holds on to your deed, and if you don't pay back the loan, they just give the deed back to the lender. Or technically, that's not correct, but it's a good saying of what happens. They just never wipe out the lien in public records. And it does where it records that you're the owner. But we'll get to that. That's a different type of ownership. We don't use that here in New Jersey, that type of system. So what is a lis pendens? It's a public notice of possible future legal action that's filed by lien holders in the public record when you fall behind a month or two, at least a month or two on your mortgage payments. Generally, your lender will give you a month to cure any defaults in your loan. So usually about 2 months into it, if you fall behind 2 months on your mortgage payments, they'll record this in your public record. Do they always do that? No, but they can, and that's the practice that they should be doing that. So could this be useful to you somehow as real estate agents, knowing this?
Absolutely.
If only there was a list that somebody compiled of everybody who's behind on their mortgage payments.
I think it is if you get with the banks, of course.
I got a couple here. No, you could sign up for them on your own.
Oh.
If you knew how to search the public records or hung out down at the County Hall of Records all day, you could find it. But here there are 4 resources where you could sign up for lis pendens lists. Okay, the first 2, NJ Lis Pendens and Realty Track, they have people, they hang out at all 21 county halls of record all day waiting for somebody to record a document in the public records that they're behind on the mortgage payments, and then they put it into a database, and if you subscribe to that, you get access to that. Okay. Um, the Red X is a tool. It's a great tool, by the way, for all kinds of lead generation things for sale by owners, expired listings, list pendants lists, etc. So that one's pretty good too. And then we have narrpr.com. This is a tool included with your or real estate associations membership. When you become members of NAR, National Association of Realtors, you get access to this tool on the website, as well as on your cell phone. They have an app called RPR, Real Property Resource, and you can do all kinds of things. You could do CMAs, you could do research on properties, you could check tax records, you could look up deeds, you could do all kinds of stuff. You even have the ability to look up and see if somebody's behind on their mortgage payments and something was recorded. Now, I'm sure there's a way that you could do a search for finding and compiling your own lists of list pendants lists. But these other ones like Realty Track, they are pretty good at compiling a list with all the information of all the parties too, the contact information and everything. But don't go calling them up or knocking on their door. What are you going to say to somebody who's behind in their mortgage payments if you knock on their door or if you call them? Just think about this for a second. Let me put this another way. What would you say to somebody who's behind on their mortgage payments? They fall on financial hard times, and you're going to try to move in there, call them so that you could get a listing for an opportunity to sell their property that they don't want to sell, that they're in danger of losing. But we need to slap them with reality that they're possibly going to lose their property. Is it the best idea to knock on their door and say, yeah, according to my records, you're behind on your mortgage payments? No, they may be yelling and screaming at you, or they may punch you in the nose. Right? When you call them up, they're gonna be like, who is this? How the hell you have my financial information? Right? So you're better off subscribing to these lists, but taking a softer approach. Send them a letter or a postcard in the mail, so it comes across like it's all good timing, as a matter of fact way. Behind on your mortgage payments, in danger of foreclosure, we can help. Now, the way we're going to help is we're going to sell your house, but this way they reach out to us. Now, they're probably not going to reach out to you with one mailing. But if you're the first one that sends them that mailing, and then you consistently keep sending those mailings, not every day, but you consistently keep following up with them, eventually when they're starting to feel the pain and they know they're in danger of losing the property, they'll call you, and then you will have an opportunity to list that property and sell it. Okay? It usually takes a little while because people are first in denial. Oh, I'm not going to lose my house. Oh, I'll get caught up. Their first gut reaction is not I got to sell my house now because I lost my job. No, they're going to wait. Maybe they'll get another one. Maybe they'll get caught up on their payments. Then they're going to try to stretch it out as long as they can. So in the meantime, you need to keep following up with those letters, because once they realize that, there may be a lot of people, they will get caught up and not lose their house. But then there's going to be some that aren't. And maybe eventually they'll break down and call you. Okay? It works. You just got to stick with the process and understand the psychology of what's going on too. Not just, I stuck something in the mail, they never got back to me. Think about what's happening. If this was you, would you be calling this postcard or mailing right away? But if they keep sending it to you, and then over time, seeing what's happening, they may eventually reach out as a resource, right? So list pendants you will get on exams. What is it? It's a public notice of possible future legal action, foreclosure, that's pending and may potentially affect title to a specific parcel of real estate. It does create a cloud on the title because the world can see there is not just a debt on the property, but it's a debt that's not being paid. So it gives Notice to all interested parties, including prospective purchasers, that someone has an interest in the property. And lenders will place the list pendants when in the public records when an owner falls behind in those mortgage payments. And I gave you a couple of resource tools here. By the way, other schools don't do this. They don't give you resources like this. I am. I just want to point that out, right? How do you educate your clients? How do you become a better real estate agent? You educate your clients. So me as a school, as instructor, how do we better inform our students how we're offering things above and beyond what other schools are? I'm pointing it out to you. Nobody gives you resources like this when they teach these classes. Okay. I'm giving you further explanations on it beyond just simply answering the question on an exam, too. Okay, now an easement. What is an easement? It's a right acquired by one party to use the land of another for a specific purpose. And can someone take your rights away? No, they cannot. Once it's been established that you have rights, no one can take your rights from you. However, you have the right to remain silent, and if you give up that right, you can give up your rights or sell them, but nobody can take your rights from you. Once it's been established, you have a rights, including with the easement. So easement is a right acquired by one party to use the land of another for a particular purpose. And easements can be appurtenant or engross. Oh, what does that mean? An easement can be appurtenant. Let me see. Easements can be appurtenant or they can be engross. So most easements are pertinent. What does that mean? It means that you have another property that is touching yours. And so people can cross over that one property to get to yours and use it for a specific purpose. I'll get into that definition in a little more detail. I want to see what this attorney has because I know I had also another video from her about explaining the different types of easements. And it's good when you have attorneys doing this. Let's see, warranty deed. Okay, how easements really work. Yes, because this is one I did not download. Explains 5 easements that decrease the value of homes. Yes, okay. So I got 2 videos here from easements from this lady. So let's look at one of them here. I'm not sure.
We're Phoenix Energy, a family-owned oil company focused on...
You exactly what you need to know about easements. In this video, property when easements are involved. If you're buying or selling property in North Carolina, this video is for you. And if you want more information on real estate.
Now, these easements apply everywhere. So I didn't edit these videos. I'm just playing this right from YouTube. Okay. So, but she does a pretty good job usually explaining these things. So let's, and I will chime in where necessary.
Estate law and transactions, hit the subscribe button. Now let's dive in. Section 1, what an easement actually is. The number one misconception I hear about easements is that people think they're giving away ownership of their property. Here's the legal definition straight from law school. An easement is a non-possessory right to use the land of another. The key words here are right to use. Nowhere in that definition does it say ownership. Think of property ownership like a bundle of sticks. Each stick represents a different right. The right to build, the right to exclude others, the right to sell. When you grant an easement, you're only giving away 1 or 2 sticks from that bundle, not the whole thing. So for you, this means when someone has an easement on your property, you still own the land. You're just sharing specific usage rights. Section 2, the most common easements you'll see. Let me break down the easements you'll actually encounter when buying property. First, utility easements. These are usually located across the front and sides of your property.
And this is called an easement engross. is a utility easement.
Duke Energy, cable companies, water companies, they need access to their lines and equipment. Here's what most people don't realize. If you see a utility easement on your plat, that company can park their trucks there, dig there, and maintain their equipment there. You can't block them, and yes, they can mess up your lawn if necessary. However, usually the easement language requires they fix anything they mess up. Second, right-of-way easements. These are for roads, driveways, or pathways. In lake communities, I see these all the time for community access to the water. You might have neighbors walking through your lot to get to the lake, and that's perfectly legal if there's a right-of-way easement. Third, drainage easements. These handle stormwater runoff. I actually owned a home with a drainage easement across the back, and it prevented flooding. It was actually beneficial. Section 3, what you can and cannot do. This is where people get confused about their rights. What you cannot do in an easement area: build permanent structures, plant trees that would obstruct access, block or prevent the easement holder from using the area, put up fences that interfere with the easement purpose. I have a family member who gets upset when the utility company works on his lawn. I tell him, wait a minute, they have an easement there, they can work there. You cannot stop them. After all, you do want utilities at your house, right? What you can do: use the area for purposes that don't interfere with the easement. Maintain landscaping that doesn't obstruct. In many cases, park vehicles temporarily if it doesn't block access. The key is this: your use cannot interfere with the easement holder's rights. Section 4, easements that aren't on your plat. Now here's where it gets interesting. Not all easements show up on your plat. Prescriptive easements happen when someone uses your property openly and continuously for years without your objection. Think of a neighbor who's been using your driveway for 20 years. They might have earned a legal right to continue. Easements by necessity occur when property gets divided and access becomes necessary. I had a case that went to the North Carolina Court of Appeals where my client
Let me give a further explanation of an easement by necessity. It's usually for landlocked properties when the only way to get access to your property is by crossing over a neighbor's property. It's necessary to cross over their property to get to yours, thus the name easement by necessity. Now let's let her finish this.
It's had an easement 5 different ways: by grant, by prescription, by necessity, by implication, and by estoppel. Here's what you need to know. These easements can be declared by a court and then added to future plats or to the public record. Even if your current plat looks clean, there could be easement issues lurking. Section 5, protecting yourself as a buyer. The bottom line is this: review your plat before you make an offer, not at closing. Look specifically for utility easements and where they're located, right-of-way easements that might affect your privacy, drainage easements that could impact your landscaping plans, any easements that reference deed books for more details. If any easement is a deal breaker for you, find out before you put down non-refundable money. In my practice, I see buyers get surprised at closing because they never looked at their plat and they didn't get a survey. Don't be that person. Let's recap what we covered. Easements are usage rights, not ownership transfers. Most common types of easements are utility, right-of-way, and drainage easements. You can't block easement holders, but you still own the land. Some easements don't appear on plats until they're legally established. The bottom line is, if you understand what easements actually are and review your plat or survey carefully, you can avoid surprises and make informed decisions about your property purchase. If you found this helpful and you want more information on real estate law and transactions in North Carolina, make sure you...
All right, so that's the one easement that she, or the one thing that she had there. I also have...
Is an easement considered an encumbrance?
It could be.
Okay.
Yes, it could be. Okay, so she was explaining more on how easements work rather than the types of easements. I have another one here from her where she's supposed to be explaining the types of easements. I want to hear what her explanations are before we get into ours here. Let's see.
There's something that could be sitting on that property right now, invisible, not always obvious, that could seriously affect what you can do with it and what it's actually worth. And most buyers don't find out until it's too late. I'm Tiffany Weber, real estate attorney in North Carolina at Thomas & Weber. I've done thousands of closings in the Lake Norman area, and today I'm going to walk you through 5 specific types of easements that can decrease the value of your home or your land. By the end of this video, you'll know exactly what to look for before you put a single dollar down. Let's get right into it. 1. High voltage utility easements. Now, every house that has utilities has some form of utility easement. That's normal. If you want power, water, or sewer, those utility companies need a way to access and run their lines. So just having a utility easement doesn't automatically mean you have a problem. But here's what most people don't realize. Not all utility easements are created equal. Out here in Lake Norman, we see a lot of high voltage utility easements, and those are a completely different situation. Those easements can come with serious restrictions on what you're allowed to build within that corridor. So you could have a beautiful 5-acre piece of land, and if a high voltage easement runs right through the middle of it, you may not be able to build the house you envisioned. You might not be able to build as large as you wanted. Or maybe you were thinking about subdividing that land down the road. Well, if the easement eats up enough of the usable area, that plan could be off the table entirely. The bottom line is this: before you fall in love with a big piece of land, find out exactly what kind of utility easements are on it and what restrictions come with them. 2. View easements. This one surprises people, especially here on the lake. A view easement, also called a site easement, is exactly what it sounds like. It is an easement that protects someone's view. So if a neighboring property owner has been granted the right to an unobstructed view of Lake Norman, that restriction could be sitting on your property. And what does that mean practically? It could mean you're not allowed to build certain structures. Maybe you wanted a covered dock with a...
All right, you know what? These are easements beyond what you need to know for exams. Okay, so I'm going to stop right here because I don't want to confuse you guys with the knowledge of different kinds of easements that, quite frankly, we hardly ever even hear of. You know, we don't have a whole
I
lot
do
of
have a
these.
question.
Yeah, yeah.
Who puts the easement on? Like, or how do we find out they're in the property?
How are easements created? Well, they could be created by need, by necessity, by utility companies, by an owner who once owned all the land and then they subdivided it and built a separate house on it. They could create an easement. There could be so it could be done by previous owners. It could be done. When you sell your land, you could create an easement on it just to try to give it more value or more access to the person who's buying it. There's a lot of ways that easements can be created, but it's
Okay.
usually by the property owner at the time. Okay.
All right. And then is there a website that we find out what that there is one for the buyer, let's say?
You get a survey, or you look,
The survey.
Yeah, the survey will usually reveal easements, but also the deed. You have to look at the deed in the public records. Deeds should also point out if there are any rights of way or easements on the property too. Okay, so
Got
yes,
it.
we can
Thank you.
search them. We have some MLSs that give us access to do that search of it too. So
So the
You're welcome.
government, like the government doesn't create easement.
they could, when they give you a permit to build, to do construction, they may require utility easements, which are easements in gross. So let's go over this. An easement can be either a pertinent or in gross. So what does that mean? An easement that grants the owner of an adjacent parcel of land an easement appurtenant. So the adjacent parcel, that is a piece of land that's your neighbor. That's a piece of land that's touching yours, not the guy across the street or across the way. It's the person it's a neighbor whose land is touching yours. That is an adjacent parcel. So if you have to have two adjacent parcels of land to have an easement appurtenant. And there's always going to be one party that's going to benefit from that easement. And then the other party whose property is being walked over and being used. So the one whose property is being used, they're called the servient, kind of like the servant. They're serving their property up on a platter to be used. And the one who's benefiting from the easement is what's known as the dominant estate. So you have a servient estate and a dominant estate. I told you, there's always at least two properties owned by different parties. Because if it's owned by one party, the two properties, this is a way actually to do away with easements. You don't need an easement right to cross over your own land. You need it to cross over someone else's, right? So you should do these highlights on page 109 and 110 here for the definition of easement appurtenant. Okay, and once these easements are created, they pass on from one owner to the next. They don't need to be recreated. They run with the land. And then the easement in gross, you should write next to the title there. It's a utility easement, for like power lines, sewer lines, your cable TV, uh, gas lines, water lines, things of that nature. And like that attorney just explained, you cannot prevent the utility company from digging up your lawn to get to their utilities. Usually, if you ever look at a survey, the first couple feet, the first 4 to 6 feet of your property, there's an easement right on it. This is why you can't build right up to your property line. There's usually a required setback. A setback is a minimum distance from your property line that any structure can be built. And often it's much greater than the distance of where the utility easement is. But utilities usually have easement right for up to the first 6 feet of your property, but it could be more because they could have the first couple feet of the property is where the shutoff valve may be, for example, to your water. But those pipes run all the way up to your house. So they got an easement right all the way up to that house for where that line is. Right. So anybody recently have a gas line? The gas company came in and dug up your lawn all the way up to your house so that they could replace the meter and maybe replace some pipes. Maybe they're replacing the water pipes, replacing those old lead pipes with copper or plastic, right? I mean, you're going to complain that you got lead pipes bringing fresh water to your house that you're going to drink, right? Everybody bitches and complains about that because you don't want to get lead poisoning, right? So, if they're replacing them and they're going to have to dig up your lawn to do that, so just bear that in mind. That's a utility easement called an easement in gross. All right. So now easements are appurtenant or in gross. So these are easements, which are rights acquired by one party to use the land of another for a specific purpose. An easement is a right. It is not ownership of the real estate. It is simply a right to use that property or to go on that property. So easement appurtenance can be easement by necessity. Easement by prescription is that one. It's kind of like a squatter's rights where they could claim ownership of your property if they've been using it for a long enough period of time. Easement in gross is the utility easements. We're going to learn about party wall agreements. There's easements, party wall easement agreements. Party wall is when you have attached housing, and it's a common wall that divides the two units. We're going to go over how to create an easement and how to terminate an easement. So once again, let's start off here. This slide shows you that an easement is a right acquired by one party to use the land of another for specific purpose. Whereas if you have a right, nobody can take your rights from you. However, there are licenses that can be granted. License is permission to enter the land of another for a specific purpose. The definitions sound very similar. The only difference there is the word right versus permission. So licenses, much like your driver's license, can be revoked at any time, but they don't need to be in writing. They can be verbal. Like you're my neighbor. Hi, neighbor. How are you doing? Feel free to come by and use my pool anytime you like. I just granted you a license for a specific purpose to enter my land and use the pool. Now, we get into an argument. I don't want you on my damn property no more. I just revoked your license. It's as simple as that. It doesn't need to be in writing. Okay. So that's what a license is. It's permission to use someone's land for a specific purpose. It's often verbal, it's not usually put in writing, and it can be revoked at any time. Whereas an easement is a right, and these are usually put in writing. and recorded with the deeds and the surveys. And once it's established you have an easement right, they cannot be taken from you. You could give it up, but they can't be taken. So let's highlight that on page 109. Easement is a right, can't be revoked. And then on page 112, go to licenses and write licenses can be revoked. It's permission to enter the land of another for a specific purpose. That's what a license is. Just let me know when everybody's got that so I could below.
Licenses on page 112. Got it. License can be revoked. Okay. This is permission. Verbal. All right. Okay, I'm good.
All set?
Good. Yes.
Okay, so easement is a right acquired by one party to use the land of another for a particular purpose. They run with the land. It passes on to the next owner with the change of ownership. A party could also have an easement right in the air above the land, or they could have a subsurface easement right to what's beneath it or in it, like we call them mineral rights. The holder of an easement only has a right, not an estate or ownership in the land over which the easement exists. You only have a right to use someone else's land. You don't have ownership of it. And easements fall into two categories. They could be appurtenant or engross. We learned that an easement engross is a public utility easement. And easement appurtenants are when you have adjacent parcels of land that are touching each other, owned by different parties. There will be a dominant estate and a servient estate, sometimes referred to as a dominant tenement and a servient tenement. Okay, so who benefits from an easement? What are they called? The party that benefits from the easement.
Dominant.
It's the dominant estate, and the property whose property is being crossed over and used is the servient. Okay. Here's a picture in your book, lot B on the left, lot A on the right. An easement appurtenant grants the rights of the owner of the adjacent parcel. So here we see an easement appurtenant to get to and use a lake on lot owner A's property. So lot owner B has an easement right to cross onto lot owner A's property to use the lake. Who's the dominant and who's the servient estate?
A would be dominant.
Everybody agree? Come on, guys, speak up. This is your safe space. Don't worry about it. You can answer.
What's the question? Sorry.
Okay, here's easement appurtenant. Lot owner B on the left has an easement appurtenant to use the lake on lot owner A's property. Who's the dominant estate and who's the servient?
Oh, B. B
B is
because
the
B
dominant.
because the B is the one that benefits from the usage of the
There you
passageway.
go. There you go.
Yes.
Okay. Something clicked, huh?
Yeah.
All right. So lot owner A is the servient because their properties are being crossed over. Can lot owner A put a fence up over here?
No. No. I get it
It,
now. You know what clicked for me?
mm,
Ministry. So I'm a pastor. The
hmm
the servant, the one who is allowing or who has the um what somebody wants to use is the servant. That's how I'm
Yeah,
gonna remember that. Got it.
that's right. So they're
Okay.
the lot owner A is the servient estate. Now they can't put a fence over here to obstruct the access to that easement unless they put a gate there with no locks on it so that they can have access to it. I mean, they could put a fence there with a gate so that if they got dogs or something, they don't get out. But they have to allow them to have access to that lake still. All right. So see, this is the thing. I want you to be able to identify who's dominant and who's serving because you could get questions like that on
So one
exam.
more quick question. When I'm looking at this, I mean, these are trees, or is this a gate? Is that a fence?
Okay.
No,
Well,
those are
well, well,
utility poles back
well, hold
there.
on. Hold on. One thing at a time because there's a lot going on in these pictures here. Right now, we just went over this easement, the easement appurtenant, which gives access to the lake. Okay.
Hmm.
So with that, there's a lot owner A is the servient estate because they're serving their property up, allowing someone else to come over, walk over their property and use it. So lot owner B is the one who has the easement right, and they're the ones that's benefiting from the easement. So therefore, they're the dominant estate. As
Hmm.
far as this, yeah, these are a bunch of trees down here. This is a bad example of
Well,
a
that's what I was trying
fine
to look
necessity.
at, because when I'm looking at it, crossing boundaries or crossing fences and things of that nature, I see the house, I see the trees, so putting in my mind where the boundaries are to say, okay, this is a passageway for them to cross over or not
Yeah.
cross over, or can they
So
build a fence
okay.
there?
So the property line is straight down here. Okay, you can see the little offset in the colors of this graphic.
Oh, the
So
middle.
yeah, so
Okay,
that's
the
where the
shades of the
property line. Yeah, that's where the
got it.
property line is on this. Okay. Now this is a utility easement for I don't know if these are telephone poles or power lines or what these are
Hmm.
here. But either way, that's easement and gross crosses over many properties to deliver public utilities. Uh, so that's easement and gross.
Okay, wait a minute. Hold on one second. Sorry. So I'm glad that you showed me that, because I looked completely past that line in the middle, which now makes sense.
Yeah,
So even that tree, if you draw the line in the middle, that one little tree belongs to really lot B.
that's on lot B, and all these other ones are on lot A. But that's not the reason why they have the trees here. The reason why they have the trees here is to show the easement by necessity. Um, uh, Okay, you guys already have this highlighted easement and gross, so we can skip over that one. Here we go. Easement by necessity. In this example, this is a poor example in this drawing for an easement by necessity. If this is the public road, you could always cut down a tree and build a driveway to get to your own property. It doesn't have to cross over your neighbors. But let's just say you live like in a super liberal place like California where you get the death sentence for cutting down a tree. You know, a lot of tree huggers there, so let's just go to the extreme. And let's just say that the only possible way, because you can't cut down a tree to put a driveway to get to your own property, is to have a driveway or a road that goes over your neighbor's property to get to yours. Okay. That's a bad example that they give here. I have a better example on the coming pages. I have better drawings of that. Well, I don't know if the drawings are that good, but I'll create some better drawings for the easements. But in the meantime, I got better drawings than what the book has here. So let me make a note for myself to get some better drawings. Okay, so an easement by necessity is a type of easement that is used for landlocked properties when it's impossible to get to your property except crossing over your neighbor's property. It's an easement that is needed for the purpose of entrance and exit, or ingress and egress, as they say in Latin. Ingress, in, that's the entrance. Egress, E for exit. That's the exit. Ingress and egress, that's entrance and exit. Okay. So once you guys have that highlighted, I'll go to the next slides. You'll have some better examples, better pictures of this. Everybody got that on page 110
Yes.
highlighted? Okay.
Yes.
So here is an example. I told you the drawings ain't that great, but they're a little bit better. They give you a little more simplicity here. Lot owner A here in orange and lot owner B highlighted in green. Okay. There's a little roadway over here, a little driveway that gives lot owner B to access to their property, which is completely surrounded by lot owner A's property. So this little driveway or roadway is on lot owner A's property. Who's responsible for making sure snow is cleared and if there's any trees that fall over that it's cleared?
A,
And why is that?
because it's their property.
There you go. Keep it simple, stupid, right? It's a simple answer is that it's their property. They're responsible for it. And they're also responsible for making sure there's no obstructions for B's access to their utility rights or their easement rights to use that roadway. Now, can lot owner B park cars along that road or that driveway?
Yes.
No.
No. It's only to be used for the purpose of ingress and egress.
Okay, got it.
Okay. They cannot park a car and leave it there because that's on lot owner A's property. They can use it to get to their property. Keep in mind, the green shaded thing, that's not a house. That's their entire lot that may have a house sitting on it.
Got
Okay.
it.
Here's another example that we often see in congested areas like cities where you have shared driveways. You guys ever hear of those shared driveways where you got two properties next to each other? Neither property has enough room to have a driveway to get to their backyard where they have their garage or their or a parking pad or something, right? To have that off-street parking. So, but there is enough room that if you share and have a driveway that's partially on both properties, there's enough room for a car to go through and then they could branch off to their own yards. Okay. This is what we call a shared driveway. And this is an easement by necessity as well. The green line is the property line here. The driveway is the blue, right? Both of these property owners are dominant and servient at the same time because neither property owner has enough room to have a driveway. So even if more of the driveway was on one person's property than the other, they still could not get their car to their backyard there without being partially on the other's property. So these are shared driveways, and both of these parties have equal rights. Neither one of them can put up a fence there to prevent and put a lock on it to prevent the other from using it. You know, sometimes if you have a bad neighbor, they could get all this attitude and pissy with you. Maybe one time you parked your car here at the entrance of that driveway so you could bring your groceries in, and the neighbor got all pissed off saying, "It's my driveway. I'm allowing you to use it so that you could get to your back." Even though it may be mostly on one party's property than the other, they can't do that because it's shared. They both have an easement right. They're both dominant and servient at the same time. So you better have good neighbors when you have things like this. But this is very common. Take a look at East Orange. East Orange, it's like against the law to park in the street at night everywhere. You're going to get ticketed and towed, you know? So if you don't have a driveway directly to your house, some people have these shared driveway type scenarios so that you can park your car in the back of the house. Okay. They're important to have, especially if you have a municipality that's going to be ticketing and towing you if you park in the street. All right, the easement by prescription. We went over this the other day in chapter 20, but we're going to go over it again right now in chapter 6. Easement by prescription, sometimes referred to as squatters' rights, can be had through adverse possession. When you use someone else's property for a period of time as defined or prescribed by state law, you can claim ownership of that property that you've been using. However, to perfect this type of an easement, it has to be perfected in a court of law. You have to file a lawsuit to claim the ownership of the property. It's not automatic. That's called a suit for adverse possession or a suit to quiet title. Now, in order to successfully be able to win such a suit, you can't just start using someone's property against their permission and boom, you're the owner because you filed a court suit right away. Remember, there's a prescribed period of time that you need to use that land for. So, in addition, the use must be continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, the use must be visible, open, and notorious. Okay, so what do these terms mean? Well, continuous means that you've been continually using the property. It doesn't mean that you have to be on the property 24/7 and never leave. It's just that you have established some sort of pattern of use that you've been continuously using it. Hostile doesn't mean that you're beating anybody up or being violent. Hostile means that it's against the owner's ownership. You know, you're doing it against their permission in a hostile way that could threaten their ownership rights. So it's adverse to the owner's title. That they could possibly lose their ownership. It's exclusive use by you, not by, say that there's a roadway and hundreds of people use this roadway as an access point, but you're the only one that then files an easement to try to claim the ownership of it. That's not exclusive use. It had to have been exclusively used by you in order to claim it. And it has to be without the owner's approval. So, you cannot claim an easement by prescription to gain ownership of someone's property if you've got the owner's permission to use your property. Okay? You can't claim ownership of someone's property who gave you permission to garden in their backyard, for example. You can't just say, "Oh, I'm the owner because I've been gardening in their backyard." Yeah, but the owner gave you permission to do that. You know, you can't claim ownership because you've been using the property now. They gave you permission. It has to be against the owner's permission. So owners should be careful when they tell people they don't want them on the property or they don't want them using it, because this starts the time clock from ticking. And now the person can, at some point in the future, claim an adverse possession suit because you previously once said that you didn't want them on the property. So once you got to be careful when you start, saying that you're not allowed, because that starts the situation where now the person could claim adverse possession if you tell them that they can't be on your property. Okay. So that's okay though, because in New Jersey, let's finish going over this and then I'll explain that a little more. Additionally, the use must be out in the open and visible. It can't be that you're sneaking on the property, nobody sees that you're using it. It has to be obvious that you're using someone else's property out in the open, notoriously, right? You got a question, Christina? I see you waving, but
I'm so glad can you hear me?
Yes.
Hold on, let me turn mine up a little bit.
Yeah, you can just ask a question. You don't have to wave because I may not notice that you're waving.
Yes, sometimes. I'm sorry.
No, that's fine.
So my question is, you know, we're talking about the permission of the properties and things of that nature. So in my business that I have right now, there are homeless people that live outside of the church. They have literally encamped on the street. So I asked the church, I said, is there anything, why do you let them live there? They said, well, it's against the law. We can't make them move because the curb is not our property. I said, well, I'm thinking that the curb is their property because they're literally encamped on the curb. They have items that are leaning on the property.
Well, you got to
Would you
see where they're you got to see where the property line is and if they got any of their junk on the actual property. If they do, put up a fence, you know, or call the police to get them to get off of your property. The if it's on a public sidewalk that's not on your property, that's fine because it doesn't affect your property, and they can't claim an easement against publicly owned land, only against privately owned
So
property.
can an easement line be as fine as this is the building, the curb belongs to the city or the state, right?
Mhm.
And then the property, this house, this building, this church, it's a church, is my property, but the curb is not my property. How does that?
The easement can be a few inches, or it could be a few acres. You know, so it depends. Do you know where your actual property line is? And if somebody's using it, you should take action to remove whoever's there. You know, um, I mean, in front of a church, having a whole, I understand the charitable purposes of church and all, but
It's an
allowing,
encampment at this point. It's a
yeah,
full-fledged encampment.
allowing those homeless encampments. I mean, if they're allowing it, they can't claim an easement. If they're saying no, get out of there, and they're there long enough and they don't remove and you don't take action to get them removed, they could claim an easement to take
I'm so
ownership.
glad that you told on this because our minds don't naturally think about the property lines, especially when it's so close together. You know, it's kind of out of sight, out of mind. You are automatically assume that this is my house, this is my steps, and this is my curb and this street. But the street, the curb, and the actual property are two different ownerships by different entities. So that was good teaching, correct?
Not necessarily, because let me give you a little idea with that. My brother has a corner property. He has a 2-family house on a corner property. His property line goes all the way up to the curb. Okay.
Wow.
But often people who have sidewalks in front of their houses, not everybody has a sidewalk in front of their house, you know, for the public, but he does all the way around the perimeter of his property, or two sides of it anyway, because he's on a corner lot. Usually the city has a 6-foot easement of your property. So there'll be like a 2-foot little grassy area, and then there'll be like a 4-foot wide sidewalk. Okay. Now that sidewalk, who does it belong to? You think it's a public sidewalk? It's actually on his property. The city just has an easement right to put a sidewalk there. So they did. And when it snows, who's responsible for removing the snow? You are. It's your property. Even though the city put a sidewalk there, it's your property. You're responsible for removing the snow. As a matter of fact, they could fine you if you don't do it within a certain period of time after the last snowfall. You know, a lot of people don't think about this. You know, what about that little grassy strip next to the curb on the other side of the sidewalk, between the sidewalk and the curb? There's usually a little grassy strip there, right? Who's responsible for trimming that grass, cleaning up any garbage on it?
So
Property owners.
I think that in that case, it is for the property owner, right, to cut that grass. But
Yep.
I'm in a situation right now where the city puts trees on that strip of grass on the sidewalk,
Yep.
right?
Yep.
And over time, the trees, the roots lifted up and lift up the sidewalk.
Don't you dare touch those sidewalks. I don't care if it creates a tripping hazard, someone falls and breaks their leg, and then they're going to try to sue you, and you're worried about that. You need to you need to contact your city and get them to fix it. Don't do it yourself. If you do it yourself and somebody trips and falls still, you're responsible, you're liable. But that's the city sidewalk, even though it's on your property. They have an easement right for it, and they put the sidewalk there. It's their responsibility to maintain it. I mean, you're responsible for snow removal, but they're responsible for maintaining that. So if roots are lifting it and it's getting all wacky, they're responsible for fixing it, not you.
And
if you
they're
can't,
trying.
and
Go
if you
ahead.
can't get any action for them to fix it, you need to get an attorney to start sending them letters. Okay.
Yep. Thank you for that because so I've been in my house 26 years this year, and there are several trees, like big trees. And so like that allows animals to be able to get into your house. Like the squirrels could get up there to get in the
Yeah.
attic.
And that's why you got to contact the city to trim those trees.
Right
Don't do it.
now,
Don't do it yourself
first
either.
the first one I did, but
Yeah.
then I had to learn as a young property owner, you got to learn your rights and
Mm,
stuff like that. So I contacted the city, and then they came and did the other ones. And now the thing is the sidewalk, the roots of the trees have
Yep.
lifted the sidewalks, and they had paperwork saying that if the tree is there, it's the city's responsibility to dot dot dot. So
Yeah.
now they're saying that there was a what's the word when they change amendment or something like that. But no, you're telling me, and I know that's right because they had paperwork for it, and they're just trying to move slow because there are a lot of trees that have done that to sidewalks, and I'm guessing they don't want to spend the money. But
Well, are you allowed to
and
cut down a tree in front of your house?
No, no, if it
No.
is in the sidewalk. If it
Well,
is inside
especially
your property,
well,
yes.
especially if it's in the sidewalk, but anything, it could be on your front lawn. You're not allowed to cut it down without permission from the city.
wow.
You may need to call the city to even do the trimming of it if it's on your front lawn, even. I'm not even talking about at the curb. I'm talking about even on your front lawn, further on your property. You may not be able to touch it. You know, in your backyard, usually you're free to do as you wish, but check with your own city ordinances. Your city council may have voted for something weird. Like our city council, not too long ago, changed our laws in our municipality, where if it's even a tree in your backyard, you need to get permission. And if you cut it down without getting a permit, they could bill you for the cost of a tree. Now, some of those old oak trees that are really tall, they could be in the tens of thousands of dollars of value. When they put a sapling, a new tree, like it's only like that thick, the base of the tree trunk. When they plant, the city can come dig a hole in your front lawn and they could plant a sapling there, a tree right in front of your house. They did to me for an old house that I had on the other side of Linden, right smack in front of my house. And then they stuck a letter in my mailbox. I'm responsible for watering it, and if I don't, and the tree dies, I'm responsible for $2,500 for the value of replacing the sapling. I was like, you got to be freaking kidding me. I specifically told them don't put a tree in front of my house, and they put it anyway when I was at work. I came home and I seen the city truck pulling down from down my street with the backhoe and a bunch of saplings on it. And I was like, son of a bitch, I know what they did. And I pulled there, boom. they didn't even put it off to the side a little bit, right smack in front of the house, which that is hard. That's the worst place to put it, because some people who follow certain concepts like feng shui, or Indian people that follow Vastu, there's certain characteristics in a house that they will never buy it. Like if a tree is directly in front of the house, if you open up the front door and you could see right to the kitchen, there's all kinds of like little weird things that quirky things that they will never buy a house if it has it. And they went and planted a tree right dead smack in the middle, right in front of my house. So, and then said I was responsible for it. Man.
Why would they do that?
Well, because at the time they had the arborists and all these environmental agencies walking over the whole neighborhood, going into people's backyards and climbing trees. They were looking for what's an invasive species of bug that came in on a shipment of wood. I think it came from a different country, but it was the Japanese beetle. Okay, you remember that? It was a whole thing about the Japanese beetle. And so they climbed every tree looking for signs of a Japanese beetle. And if they found a Japanese beetle or signs of a Japanese beetle in a tree, they would cut down the tree and put it in a chipper on the spot. They had this ginormous chipper that they brought in, where they could feed the whole trunk of a tree whole into it. So I had 5 trees alongside my driveway all the way up. I looked into how much it would cost to get them removed, and it was super expensive for each one. Plus, I would have to get the city's permits to do it, and that wasn't happening. But they came. I seen all these environmentalists climbing all over. They were like cockroaches everywhere. These people going through people's backyards and climbing trees and stuff. And I was like, what the hell's going on? They're like, oh, we're looking for a Japanese beetle. We're with the Environmental Protection Agency or the Arborist Group or whatever it was, that all these different environmental groups, and trying to prevent the spread of this beetle by killing it before it really spread out. So what they'll do is they'll hollow out the tree and live in it and use it as their nest. So they went through all the trees, for 1 tree, 2 tree, 3 tree, 4 tree, the 5th tree all the way in the back. They found a Japanese beetle, and then they showed it to me what it looked like. It was like really shiny black with these yellow stripes, kind of looked like it had like lobster claws, like little lobster claws on it. It was really freaky looking. But they found one. Now, the only way to get to that tree was they had to cut down the other 4. So I got all 4 of my trees cut down by the city, or the environmentalist group or whoever it was, but they came in with a crane and this big ass chipper to chip up the tree whole. Like they cut the branches off and put that through the chipper, but then they took the crane and they took the trunk and they fed the entire trunk into this big chipper so that it could kill the beetles that may be inside of it. They don't want to cut it down in pieces and then have them escape and get all over to neighboring trees, So they had to feed it directly into the chipper. But it was interesting. I got a video. I can't find it, but it's on one of my old computers. I didn't throw them away because I know I got it somewhere. I took a video of the crane lifting up one of the trees, and they lifted it and swung it over my house into the street. They laid it down, they lifted up the end, and they fed it into the chipper. It was a sight. So then they came up to me like right after they did this, and they were like, okay, here's a brochure with all the different kinds of bushes or trees that we could plant for you. I was like, no, I don't want anything there, because I was actually trying to get a permit to put up a 2-family house. So I was like, I don't want anything there. I don't want you building anything. I don't want you planting anything there. I wanted to get rid of those trees. I don't want to replace them with another tree. And then they did it anyway. When I wasn't home, they came and they dug a hole and they planted a tree right smack in front of my house. And I'm like, you sons of guns.
Could you have moved the tree over, like to the side?
I don't know. I didn't. I didn't attempt to mess with it. It was a big tree. You would need heavy machinery to it. I couldn't lift it, because the base of the tree is like this with big heavy roots and dirt in the burlap bags that they put in the ground. You need their heavy equipment to move it. So, could I have moved it? Yeah, I guess if I got the heavy equipment, I could have. I don't think they would have noticed the difference, but even with that, I can't dig a different location. You got to call, what's that number? You got to call that number before you dig to make sure that you don't hit any utility lines. So I'm not sure where the utility lines, I'd have to get them to come map them out and all that before you could dig and move the tree in the front of the house as well. So that answers that question. All right. So let's continue with the easement by prescription here. So the prescriptive period in New Jersey is 30 years for improved lands and 60 years for unimproved woodlands is required to make the claim. So now this law is going to be changed in the future sometime. They're going to do away with the 30 and the 60-year period to go with a 20-year common law period. But until that happens on your exams, it is still going to be 30 years for improved lands. So if there's a structure on there, or 60 years for unimproved woodlands. Okay. You need to know those prescriptive periods for exam. And through the process known as tacking, even though you have to have one person that's exclusively using the land without the owner's approval, if that person used it for 25 years and then they died and their son continued using it for another 5 years, they could tack on, successors in interest can tack on one person's use of time onto the others, combining them to reach the prescriptive period where they could then claim adverse possession. Okay, so successfully. So how does an owner prevent someone from claiming adverse possession and perfecting an easement by prescription? Well, an owner can take legal action against any adverse possessor to remove them from the property. It's not enough to just post no trespassing private property. If somebody's on the property, you got to take action to get them removed, call the police, file a complaint so that you could have it heard in court and have a judge remove them. It includes those homeless encampments, right? You've seen how they were working out there out west, right? In California and in Washington State, right? It's a mess. You could cut off their access, maybe put up a fence, that cuts off their access to stop the continuous use, and that also resets the time clock. Or you could give them permission, give them a certified letter, say you got permission to be here till the end of the week. Then you got to go. Well, because you gave them permission, it reset the time clock. So even if they're like close to the 30 or 60-year period, if you gave them permission, you reset the time clock. I gave you permission to be there till the end of the week or the end of the month. Then you got to go. That reset the time clock. So they would have to be there for another 30 or 60 years to be able to successfully make the claim. And as I have noted down at the bottom, an easement by prescription cannot be claimed against public property, only private owned property. And it's usually against farmland, but not necessarily. Okay. So let's do these highlights on page 111.
So you said that if we tell them that they have to move, then we can be liable for it. What will be the reason? Like, I know you explained recently
Okay.
that how to get them out, but if I tell them like this is my property, you need to go, I'm giving them access to lawsuit.
Well, what is the condition in order to claim an easement by prescription? It has to be out here. Must have been continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. If the owner gives you approval to be there, they can't successfully claim easement by prescription through adverse possession to take ownership of your property. You cannot claim adverse possession from an owner who gave you permission to be there. And this resets the time clock. So you give them permission to be there and then say you got to be out at the end of the week. So you gave them permission, that reset the time clock, and then you say you got to be out because you really want them out, you know. But this is a way to avoid them to be able to make that claim in court. Did that answer your question, or did I not answer it properly?
No, yes, that's fine.
Okay. All right, so do all these highlights, and I want you to also write here or take legal action over here because it shows how you could prevent somebody from gaining an easement by prescription. You could specifically grant them permission, or take legal action, or cut off their continuous use, maybe putting up a fence. Or just get a mean dog. Okay, so just let me know when everybody's got those highlights and notes.
Here go another one. Regardless, legal action must be taken to perfect the easement. Got it. All right, I'm all set now. Finish.
Okay, everybody got the notes highlighted and written down for the slide? All right.
Yes.
So, and then this is the one from chapter 20. There's a section talking about adverse possession that we've already highlighted already as well. So you don't got to go there and do these highlights over there. But you do need to know about the 30-year and the 60-year period if it's woodlands. You have to know about the suit for adverse possession, also known as a suit to quiet title. You got to know the term tacking. That's where continuous periods of adverse possession can be combined from different parties to reach the prescriptive period as required by law to perfect the claim of adverse possession.
What page is that?
And this one you do not need to know, but inverse condemnation, that's where a city puts in so many restrictions on how you can use your property through zoning laws and other regulations that they basically render your property useless, devaluing it without giving you compensation. You could actually sue the municipality in what's known as inverse condemnation to get paid for that value of your property that they took from you without just compensation. Okay, now here's an example of a public grant. That's when when the government gives property to public property to a private citizen. Here's an example of actually a listing I had in Piscataway. You had a house here, had a pool in the backyard. This was all fenced, and the owners cut this corner lot that was attached. Now, this was a city lot. It looked like it may have been theirs because they had a volleyball net on it, and they used to play, use it. They maintained the lot, so they cut the grass. They put up a volleyball net. The city never came by, so they actually used this corner lot, which looked like it was part of their extended property, but it was actually the city-owned lot. They could ask the city to give them to publicly grant them ownership of it. Okay, that's public grant is when the municipality gives ownership to you, but you cannot claim adverse possession because you've been cutting the grass and maintaining it for years and years and years. That you're now the owner. Okay, cannot be done against city-owned property, municipal property, but you could ask them to give it to you, and then you'll pay additional taxes for having a bigger property, right? Here's an example of, you see the big fat black line over here shows you the property boundaries of this property. And there's down at the bottom, that's where the street goes across the stream. So this property owner subdivided their land to build 6 houses, and they built a cul-de-sac street. A cul-de-sac street is a street that comes down and then it has that big round turnaround at the end of it. Okay, we call that a cul-de-sac. So the property owner that did the subdivision and sold all those houses, there's no reason for them to keep the street ownership that was built on their land, because all of this was their land. All these houses and the street were built on their land. After they sell off all the houses, there's no reason for them to keep that road that they built, keeping the ownership of it. So they could dedicate it to the municipality. Dedication is when you give land to the government for a public use, like streets, schools, or parks. So here's a common example where that would be done. You have a big piece of property, you subdivide it, you built 6 houses on it, you put a street on it, you dedicate the street to the municipality. You have to notify that when you're submitting the plans for all of this subdivision and construction, you have to submit those plans and let the municipality know in advance if you're going to be keeping this street private or if you're going to dedicate it. You still get to name this street, by the way. But that's what dedication is.
Right. Okay. So now what benefit is that to the owner that they dedicated?
They don't need to maintain the street. Plowing the roads, or when it gets busted up, they need to dig it up and repave the roads for, because that's the only property they would still own is just the street. Why would you want to own a street? You're not getting paid for having a street.
No,
you're just paying taxes on it.
I just didn't know. So that.
Oh, no, I'm not shouting at you. I'm just explaining.
No, that makes sense, because I'm like, why would they try to take everything from us? Why would we want to give anything to the municipality? But that's good. The responsibility of maintenance.
Yeah, you're just passing it on to you're giving the land that the street is on to the city, to the municipality.
Okay.
Why would you want to keep it? You sold the houses. Why would you need to keep the road?
It makes sense. Makes sense. Yes.
All right, here, let's do a little Cash Cab trivia for you. Okay. You guys ever hear of Cash Cab? The video, the game show? It's a game show that takes place in this taxi cab driver's taxi. And he asks random trivia questions to people, and they rack up the money as they answer the questions right. If they answer 3 questions wrong, he stops, pulls over, and kicks them out wherever they are. So this was actually a game show. You could still see reruns of this. There's years and years of it. It was on TV. They have reruns of it on the Game Show Network on TV. It's a great program. And the guy was a comedian too. But let's see. While he was trying to get his act together, he was still driving a taxi, and he said, "Hey, you know what? What the hell? Might as well turn this into a game show." And he did. And he got sponsors and he got money he gives out to people, and it actually was a hit. All right, so let's check this out. Let's see if you guys can answer this trivia question correctly. So let me jack up the volume here a little bit. I'll optimize the video and see if you can answer this correctly. Ready? Here we go.
What term for...
Oh, that's too quiet. I got to raise the volume a lot more in order for you guys to hear this here. Let's see.
What term for a dead-end street means bottom of a bag in French? Ooh, ooh.
Anyone? What term for a dead-end street means bottom of the bag in French?
No idea.
Is it cul-de-sac? I'm afraid it is. Cul-de-sac is correct.
So there you go. The term cul-de-sac actually means bottom of the bag in French. So I guess it's got that skinny part, and then it goes out and it's round like that. Kind of looks like a cul-de-sac street.
Oh, wow.
Right? So cul-de-sac is a French term. It means bottom of the bag. Interesting, right? Interesting trivia. Look at them. They're up to $200. Okay, we got another one. We got only one more of these I got.
What term for it?
Okay, here's another one. Let's see what this one is.
These next questions are worth $50 each. What Chinese spatial philosophy is used to determine sites for graves and house design?
What he said, if you didn't hear it, is what Chinese spatial philosophy is used to determine sites for graves and house design?
Is it feng shui?
Let's see.
Feng shui. That is correct.
Ding, ding, ding. You won $50 if you were on Cash Cab. Yeah, that's pretty neat. He's got all the lights that go on, and he gets the sounds going, speakers in the cab, It's a pretty neat game show. If you guys never seen it, look it up. I
used to watch that. I did. I used to watch that.
It's a good program. I liked it. I still watch it from time to time. There's still episodes. It was on for so many years. There's still episodes. I could binge watch it and still find episodes I'd never seen.
Next question.
All right, now let's talk about that easement by prescription just a little bit more. Here's a graphic that I put up here. We got lot owner A on the left, lot owner B on the right. This black line is where the property line is separating the two properties. This red dotted line is where there is a fence. Now that fence has been there for at least 30 years. I don't know who put the fence up, but lot owner A could claim an adverse possession because of this piece of property, of this land, and take ownership of it, because that fence has been there and they've been using this land over the property line for at least 30 years. Why is 30 years the magical number? Because 30 years is for improved lands, and there's a house here, so it's improved. Okay, it would be 60 years if it was unimproved vacant woodlands. All right, so they're there for 30 years. They could claim that. Now, who put that fence up over there? I don't know. Maybe it was lot owner A. They didn't know exactly where the property line is, so they put the fence up over on the neighbor's property. Or maybe it was lot owner B. Maybe they didn't know where the property line is, and just to be good neighbors, they wanted to put it in a little bit so to make sure it's not over the property line. And then over the years, they started using all of that land, assuming it was theirs. I've got the same situation for my neighbor on my left-hand side, because right along the property line, there are trees. There's a couple trees right over here along the property line. Now, those tree trunks are halfway in my neighbor's property and half on mine. So I didn't put the fence this far in. The fence is like right against the trees and then it starts curving towards the property line. But it's inland. I've got the trees on my property. I'm sorry, I've got the fence on my property. And those trees, which are partially on my property, are on the other side of the fence. Okay. So as far as the neighbor knows, that fence is the property line, but it's not. It's actually a couple more inches over. Okay. Oh, so how can lot owner B prevent lot owner A from claiming an easement by prescription and taking ownership of their land over here because the fence is there?
They gotta get
Well,
a survey first, right?
well, maybe if they don't know where the property line is, they would need to get a survey to find out where it is.
Oh,
Well, let's
okay.
just say they know where the property line is because there's actually survey stakes still in the ground. If you take
Oh,
if you take a metal detector and walk around, you may be able to find the iron stakes that were pounded into the ground so that your lawnmower, you don't run over them with your lawnmower. So they pound them into the ground below the dirt level. And you may be able to locate them with a metal detector. And then you could dig a little hole, you could see them, you could pull it up out of the ground, tie a string around one to the other. Now you could visually see where your property line is. Okay, this is why it's good to get when you get a survey done, to pay the extra money to have a surveyor put the stakes in the ground at each of the corners of the lot. And then you could, in the future, you could just look for those or just pound them back down into the ground when you no longer need it. This way, it helps you if you ever want to put up a fence or anything, you could visually see where the property line is. So let's just say that that's already done. We don't need to get a survey done. So we know where the property line is, and it's here. Okay. So what can lot owner B do to prevent lot owner A from gaining ownership of this piece of land that they've been using? Well, they could take A to court to get them to stop using it. They could give permission for them to use the land, or they could cut off their access by moving the fence and putting a fence right there on the property line where it belonged to begin with. Okay. Now, if it was lot owner A that put this fence up on lot owner B's property, can lot owner B just tear down the fence that was built on their property? Let me ask it a different way, a different type of a scenario, asking the same question. Lot owner A put up the fence over here, over the property line. Can lot owner B just tear down that new fence that they put up? I don't recommend it because you're destroying their property, even though they built it on yours. That would be like, what if lot owner A parked their car in your driveway? Could you take a sledgehammer to their car? Because why not? They parked it on your property. Well, you're better off taking the legal route, calling the police and getting it towed, right? That's kind of like taking lot owner A to court and getting them to remove it. All right. Because if you damage their property, they could hold you liable for the value of the property you damaged, even though it's on your property. Okay. And don't assume where property lines are or who placed the fence there. Because when you assume, look at this little clip from the late great Benny Hill. Whoop, where's the volume?
Never assume, because when you assume, you make an ass out of you and me.
That guy was a trip. British humor, he was way before his time. He was a great comedian. If you guys never seen Benny Hill, look him up. I'm sure you could see him on some comedy networks or the skits online. Usually it was him and this little old guy that he was always with, patting him on the head, this bald guy, and kicking him in the butt. That was his real father in real life. I don't know if anybody knows that. Funny show. Benny Hill. Assume. Okay. Oh, there's some resources for him.
Attorney or for just a property owner.
Yeah. Let me see that. At the end of that clip, there was some resources there for Benny Hill. Let me see. There we go. He's on X, the Benny Hill, Benny Hill official on Facebook, or there we go. So Benny Hill, great, funny videos. A lot of funny videos.
Can I ask you really quickly?
Sure.
If the property owner, like the example you said, would you, like, let's say you didn't want to use a lawyer, would you submit like the paperwork to the court or to like your town? That's how you would do?
You could just have a process server. What? Okay, well, hold on a second.
Of you.
Come on, what's going on here? Okay, so you could file a suit. You call the police, you file a complaint, and then it would go to court. And you don't need to hire an attorney to do this unless it's a business. Okay. Let me mute that. You could go to court, and you don't need a judge unless it's a business. Okay. If you're running a business, you need to get a lawyer. But if it's not a business, you could just go to court yourself and make the claim. But remember, you're trying to protect your land here, so maybe a better idea to have an attorney involved, but you don't need one. But it is legal stuff, and they have a little, if the other side has an attorney, you're probably better off having one too. But yeah, you could just go to court without an attorney and try to argue it and show your evidence to a judge, but you better come with some sort of evidence and argument there. That it is your property and why they can't claim ownership of it. Okay. You could hire somebody to serve them with papers, either a process server or a sheriff's officer. You could pay them a fee to serve documents, to serve like lawsuit papers or papers like this. And now you have the proof, because they'll give you a letter showing that these papers about this were served to this person when. Okay, so you'll have that evidence that they were served with documents to saying that they can be there on the property till the end of the week, but then they need to move, get off your property. That's a way of resetting the time clock and then calling them out. And now you need to take legal action to get them removed, because if they stay there for however many more years, they could claim that easement against them. All right, now here is an attorney, a different attorney. This is one that this is a video of an attorney where she is explaining how easements work, and she explains farmland versus city. She's explaining it as if she's explaining it to other attorneys, not to us as real estate agents or the general public. Okay, the difference between us, between that other attorney and this one. Now the audio is it's got some popping and a little background noise on it. It's not that great, but it's the best video I could find. I'll try to get it cleaned up somehow with some audio tools. But in the meantime, this is the best that we got. So let's listen to her explaining how these easements by prescription and adverse possession works. All right, so let me turn off the videos and minimize them, and here we go.
For an attorney or for just a property owner, I think a lot of times people don't even realize that this body of law exists. Maybe when you own your first home or you get your first survey, you start to realize how important boundaries can be. My name is Jessica Shrestha. I'm an attorney at Wheeler, Van Sickle & Anderson. That's here in Madison, Wisconsin. The concept of adverse possession is that, well, first everyone has a deed to their property. There's a legal description, there's a boundary, whether it's a lot or something else, specific distances, and that's your boundary. But as everyone knows, it's hard to figure out where those are, and a lot of times actual occupation on the ground doesn't necessarily match the real boundary lines. Sometimes it's a matter of a few inches, but sometimes it gets to be, we're talking feet acres, a whole 40-acre parcel sometimes. And it turns out that if you occupy and use an area of property for long enough and treat it as your own property, the doctrine of adverse possession makes that your property by law. It's more complicated exactly how that applies, but that's the basic concept. Over time, property can become yours even if you don't have a deed that describes it. Adverse possession comes up most often for a typical property owner with a fence. That's really the classic example, and that has been for as long as we've had, real property and the law of adverse possession. Someone will construct a fence, and even if they get a survey to tell them exactly where the property line is, they might construct their fence a foot inside their property. They want to make sure they can stay on the other side, for example, or a foot on the other side. Sometimes it's a greater distance. And over time, they forget, or maybe they didn't know where the exact boundary was in the first place, and that fence might become the boundary by operation of adverse possession. Same thing goes with lines of trees and hedges, or even people might place a shed on a neighbor's property. And that's in a city lot. The same thing, though, can happen with pasturing cattle or with fences for cropland. When a client or a potential new client comes to me and they think they have a boundary dispute or maybe an adverse possession situation, to start, I think the easiest way to think about it is you have to ask the basic questions: the who, what, when, where, why, and how. The who is really important. Who are the parties involved? And with adverse possession, it's not going to just be the current property owner necessarily. Do you have a governmental entity? Who owned that property 20 years ago? The what sort of property is involved? Is it hunting property, a city lot? Those are important things to know about property and deciding if you have adverse possession. When? Are we talking 20 years of adverse possession? Was it occupied between 1930, 1950? What time period? Where? How much property is involved? What is the actual boundary line that's in dispute? And why? There's a recent case, again, Wilcox versus the state of Hines, that told us it is important why you were possessing the property. Did you intend to possess it? Was it with the permission of the true owner? Did you think it was your property? And then very importantly, how? What were your acts of possession that constitute adverse possession? When I have all of that information, I sit down and I think, does this equal adverse possession? I compare it to the case law. And then I start to think about possible defenses and different related doctrines maybe that could come into play, such as the doctrine of acquiescence or easements. Attorneys should know that the statute isn't going to answer their question in most cases. You need to look at the entire body of law that has developed over time. The adverse possession statutes actually codify the common law, and so there are different elements even in the cases than ours are listed even in the statute. So the elements of adverse possession are continuous, exclusive, open and notorious, and hostile possession, whereas there is no reference of most of those terms in the statutes themselves. Attorneys also need to know that you shouldn't just look at either the first case or even the last case. It's been a long and complex doctrine that has evolved over time, and a good place to start is probably the latest case, but there are plenty of cases from over 100 years ago that I still reference and that are still relevant good law that you will need to be aware of. Part of why I wrote my article is sometimes it's really hard to find a good summary of adverse possession law. A lot of the treatises will have it, but that's on a nationwide basis. And our state, along with a lot of other states, has developed the law in its own way. So I think the best way to sort of follow along and know what you should be looking at is to just go through the cases. You're going to have to do your case law research. Hopefully my article will give you a good starting point, but from there you just have to get into the topic.
Okay, so there's a full explanation.
For an attorney or for...
So there's a full explanation from an attorney about it, as if she's explaining it to other attorneys, because there's so little information out there that you could find when doing research, which I found as well, that problem when trying to find good resources and explanations for people when creating this class. So I found this video by her. That explanation was pretty good, explaining it. It could be a farmland, it could be a city lot, it could be a few inches or a few acres, and how exactly does somebody successfully claim adverse possession. So you get a lot of these idiots on YouTube now. They hear about adverse possession and they think that they could just break into a house, change the locks, and file a few papers with your local court to claim adverse possession, and that's what they do. And then it creates problems for the property owner. They may have trouble getting them out, especially if it's a state that you're in that is that crafts their laws to be a tenant protection state, that favors tenants more, because these people could claim maybe that they have a valid lease, or maybe they're just claiming adverse possession, and then it's hard to get them out without evicting them first. I'll show you a couple examples of that right here.
A bit more bizarre business story. We're going to talk about the headlines about the young man who moved into a $2.5 million mansion near Miami without paying a dime. We first told you about this story Friday morning, but we're now learning that this has become a national trend, and some of the people doing it are even connected to an anti-government group the FBI classifies as domestic terrorists.
That's those sovereign citizens. If you ever watched Cops, they're like, oh, I wasn't driving. I don't need a license. I am a sovereign citizen. I am just traveling. So you weren't driving a car. No, I was traveling. I don't need a license. You guys all seen these idiots before, right? They think that the laws don't apply to them. Well, that's what's going on here.
Boca Raton, one of the poshest zip codes in Florida, is abuzz this morning over what is happening inside this $2.5 million, 7,500 square foot waterside mansion. The bank foreclosed a couple of years ago, but now a 23-year-old named Andre Barbosa has simply moved in.
Nobody's happy. We all spent a lot of money to live on this street.
Barbosa is using an obscure legal concept on the books in every state called adverse possession, which says if you live in an empty home for a certain amount of time, it's yours. Adverse possession is being attempted all over America. Susan Weidman took over a series of homes in the Atlanta area.
I filed adverse possession back in February as Susan Weidman at the DeKalb courthouse. So I'm not just, transient squatter here.
This $3.3 million house near Raleigh, complete with an elevator, got caught up in this whole mess when Sean Pendergraft claimed he owned the house.
It's not a scam. Everything we're doing is lawful.
There have always been squatters, but the housing crisis has put the phenomenon on steroids. Some of the people using adverse possession are connected to a sometimes violent anti-government movement known as sovereign citizens, who believe U.S. laws do not apply to them.
A police officer walks up to someone who is claiming a house now belongs to him without any basis at all, is handed a big sheaf of documents which are incomprehensible. And I think very often the officers ultimately feel that they're forced to go back to headquarters and try and figure out what's going on before they can actually toss someone in the slammer.
I met a young sovereign named Robert Peterson who moved into this foreclosed home in Idaho.
They're the enemy. They're the enemy of anybody who wants to live free.
One expert on sovereigns found evidence to suggest that Andre Barbosa, in that mansion in Boca Raton, is connected to a sovereign group called Divine Province, based on the language Barbosa used to justify moving into the mansion and the fact that his name is on the group's website. Before you get any ideas about trying to use adverse possession, consider that the sheriffs forced Robert Peterson out of this house, and remember Susan Weidman, arrested for racketeering. And Sean Pendergraft, also arrested for obtaining property by false pretense.
All the legal arguments he may make or the documents he may file will all end up leading to the same conclusion. And that is that he gets kicked out because he has no legal right to be there.
As for Andre Barbosa, he may be running out of time in that mansion in Boca. Bank of America has now filed a claim in court claiming it is the rightful owner of the home.
It's so crazy that they're arguing that the law's on their side.
They are, and they're kind of 1/3 right.
Fascinating story. All right.
1/3 right. See, a little knowledge can be a dangerous thing, stressing the little part. Here's another example.
Now a warning about the risks more and more people are taking to get a house for next to nothing. It's an obscure law some hope to cash in on, but often land in jail instead. Our Chris Trankman joins us live in Polk County to explain more on this. Chris?
Well, the sheriff says some people never learn. This is the house in question. It's valued at $160,000.
Hold on, let me hold off for a second. remember, adverse possession, the whole idea behind adverse possession is you're trying to perfect an easement called an easement by prescription, where you could take ownership of somebody's property by adversely possessing it. Now, you have to use it for a prescribed period of time as defined by law in your state. Different states have different prescription periods to make the claim. This is this example here is in Florida. Florida has a 7-year prescriptive period. All right. Remember, in New Jersey, we have 30 years for improved lands, 60 years for unimproved lands, and both of those are eventually going to be changed to the 20-year common law period. But I just wanted to give you a little lead time in what's going on in this story. Also, this sheriff, you've probably seen him on TV for various things. This guy's a trip. He is funny as hell. But he's all business, but he's a funny guy. Check this out.
It's in foreclosure, and both deputies and residents here are baffled why a couple thought by breaking in, turning on the power, water, and cable, they would have the right to own the house without paying for it.
With the homes being vacant, it just takes neighbors in the neighborhood having their eyes and ears open.
Danny Rodriguez says residents along Echo Lane noticed a locksmith changing the locks and moving trucks unloading furniture into this vacant house. As the Homeowners Association president familiar with his neighbors, Rodriguez suspected a scam.
I knew a little bit about adverse possession just from doing some research at saying you need to be in the home for 7 years, and I knew they weren't here for 7 years.
Adverse possession is a Florida law from the 1800s that applies to unoccupied farmland. The property appraiser alerted sheriff's deputies about Sherry Fields and her husband after they filed for the obscure law. They were charged with burglary and grand theft. Meanwhile, Sherry Fields is a teacher at Fort Meade High School.
Come on, girl. You know, you got a college education. You should know better than that. But anyway, we gave her a field trip to the county jail.
Sheriff Grady Judd says more people are learning about adverse possession from websites online, mistakenly thinking they can use the law to take over an unoccupied house for free.
Of course, we all know if it's on the internet, it's got to be true. Well, what they didn't see on the internet was my Facebook page that says, "We will put you in jail."
You know, we work hard for our homes and what we have, and it's not fair for someone to just come in and take somebody's possession like that.
And the sheriff says the school teacher and her husband are going on another field trip, this time for a crash course on Florida law. They'll be in a courtroom tomorrow. We're live in Polk County. Chris Trankman, ABC Action News.
Now a warning about the risk.
That's funny. Well, he gave her a field trip to the county jail. Come on, girl. You know better than that.
Now a warning.
All right, here's another one.
Caught in the act, how one woman stopped a group of squatters from moving into a vacant home.
Okay, so this is a little bit different here. I'm going to rewind this. And this is, again, this one is in California. But New Jersey laws are very similar to California. We're a blue state where we've got some very liberal laws here, just like California. We usually adopt laws after they're passed in California as the testing ground. And New Jersey is a state that is a tenant-friendly state. So they craft the laws that favor the tenants more. And so if you have criminals out there that know a little bit about the law, they bend it and use it to their advantage. So in this video here, it explains how somebody can use these rules to get into your house, and then it's difficult to get them out. And this could happen in New Jersey as well. So that's why I'm showing this.
In the act, how one woman stopped a group of squatters from moving into a vacant home she owns. Good evening, I'm Jackie Parks.
And I'm Todd Carley. 23 ABC's Mark Christian is live tonight from a home in Oildale where those squatters were trying to take up residence. Mark?
Well, guys, if you think
think if someone is living in a home illegally, it'd be a simple case to get them out. Well, squatters move under the radar to try to move in very fast, and in some cases even changing the lock so they can move in before the owner finds out.
I saw like about 20 people at my property trying to move in as fast as they could.
After her previous tenant moved out, the home had only been vacant for 10 days.
Unfortunately, some of these squatters have gotten pretty sophisticated.
Rena Chanty was getting her home ready to put it up for rent when a neighbor called to tell her someone was trying to move in. The squatters were moving in a refrigerator, a washer and dryer.
Basically everything a house needs. They were even putting up their decoration pieces, and they had changed the locks.
When deputies arrived, the squatters were still in the process of moving in. Though not commenting on this specific case, Ray Pruitt with the Sheriff Department says squatters can take refuge under the California tenant law, and they've even been known to falsify rental agreements.
Once they're in that property, in some cases it's very hard to get them out of that property without legally evicting them.
In cases like this, law enforcement's hands are tied because if the squatter presents what appears to be a legal agreement, it comes down to he said, she said.
Sometimes we can't determine if the squatter's in the home legally or not.
They know the system and they know how to play the system.
Fortunately for Chandy, the squatters did not get that far and could not provide any documents to law enforcement.
At that moment, the cops told me it was my word against their word, and I had to prove that I owned the property, which I had the paperwork on me.
So right now, Chandy is checking her house daily until she can officially get it rented. In the meantime, she's asking her neighbors to keep a watchful eye until that place gets rented. Back to you, Jackie.
It's insane. It's insane how what people do, knowing it's not their property, that they're just going to move in and try to take over. And this problem has exploded with all the illegal immigration that's happened. There's some of these charitable groups, or I don't know if you could even call them charitable groups. I think they're more like political party groups that are coaching people on how you can take up residence in someone else's vacant house just by moving in and changing the locks. As a matter of fact, not too long ago, we seen this one guy in the news who was bragging about it. His videos were going viral. They were on like the mainstream media's news networks, where the guy, he was bragging about, he couldn't speak English, but he was bragging about, and they had the translation underneath, how he was bragging about how in America you could take whatever you want and it's yours, and how he's going to do it, and there's nothing that immigration or the president can do about it, and and he was laughing. And eventually, of course, the president seen that, and he was like, oh, hell no. So they went after it and they found him and they arrested him and then they deported him. But this is a guy that was actually moving into people's houses, breaking into them and setting people up in other people's homes, and they're navigating the system just like this. They're playing the system. Just like those YouTube guys that tell you how to be an adverse possession investor. An investor in adverse possession, you're breaking into someone's home, changing the locks, and they don't move in. They're actually renting it out to someone to collect the rents in the meantime. It's really crazy stuff.
Caught in the...
And here's an attorney here and giving an example where someone else is doing that exact thing that I just explained. But here's an attorney that's advocating for them and saying, well, it's part of the law, so it's something you could do.
How come you're running away from me? If it's all legal, stay and talk to me. There may be a good reason why this guy didn't want to stick around or explain how he helped two families move into this Coconut Drive house. Terrence Smiley tells me this man he knows as Enchino Hernandez offered a deal on this house that was too good to pass up.
He say he have a house. Go check it out if you want it. We can do business.
Turns out the guy dashing off in a hurry doesn't own the house, but Smiley says that guy offered to rent the house to Smiley for $500 a month. The guy denies that. He claims he just charged Smiley $190 for advice about a form available at the property appraiser's office and a little-known law called adverse possession. Adverse possession allows someone to take ownership of abandoned property if they live on it and pay taxes on it for 7 years. What's happening in the Bay Area is a lot different. An 8 on Your Side investigation found some people are turning the adverse possession law into a money-making scheme, taking control of vacant properties and then renting them out.
Do you believe that you've committed any violation or crime or misdemeanor?
No. That's what Steve Bible told me more than 3 years ago. He moved 31 families into homes he didn't own, filed adverse possession papers, and collected monthly rent. He's now in prison, serving 5 years for fraud.
The Hillsborough County property appraiser tells me there's been an explosion of adverse possession forms coming through his office in the past few months. So we set out to find out who's filing this stuff.
We visited house after house after house, all of them listed on adverse possession forms we obtained from the appraiser. Most are vacant. But at this townhome, Alice Fugate had a big surprise after she signed a lease with the real homeowner.
We had squatters in here the day before we moved in.
These new renters found other people's stuff inside. And 2 doors down at another home on the adverse possession list, we found a cable TV installer waiting to do his job.
They can stay there if nobody kicks them out.
Stetson law professor Darrell Wilson says adverse possession is a technically legal way to take over abandoned property if the right steps are followed.
You would think that the person who owns the property would come and police their property. The law helps those who help themselves.
Where we draw the line is breaking into somebody's home.
But the Hillsborough Sheriff's Office takes a hard line on adverse possession.
It belongs to somebody, so stay out of it. If you go inside of it, you break inside of it, we're going to arrest you for burglary and theft.
So you the landlord here?
No, I'm not.
Then why'd you rent it to these guys?
I didn't rent it. They went down to the courthouse and did that.
This guy tells me he doesn't charge people like Terrence Smiley rent. They just pay him for his adverse possession expertise. He later agreed to talk to me, but the phone number he gave...
The mobile number you have called is no longer in service.
These tenants could end up in the cold. Detective McKinnon says the sheriff's office typically gives renters in adverse possession cases 30 days to move out.
Innocent families, it's just bull crap, man. Really bull crap. You work hard for your money.
In this case, and so many others, adverse possession adversely affects people's lives. Peter Bernard, News Channel 8.
And that's you could see YouTube videos teaching you how to do this. And as you could see, that one guy ended up in prison for 5 years for taking properties by adverse possession and renting them out to others for properties he don't own or have any interest that he could actually win an adverse possession case on. So it's fraud. What about some property line disputes? You ever see an issue like this? This guy put up a fence protecting his property line for the property that he bought at an auction. He was trying to get the city to give him, to work with the neighbor if the city would agree to give him a variance that allows them to build on a smaller lot than normally allowed. The problem is this property was subdivided, but a house was built on it, and half that house was built over the property line. What do we call that when you build a structure that goes over the property line? Begins with an E.
Not encroachment? No.
It's an encroachment, correct. So they are encroaching into the neighbor's property now. So this property was subdivided, even though there's a house on it that's encroaching onto the neighboring property. The guy bought it at auction. And, he tried to get a variance permit. The city said, oh, your property's too small to build a house on. So he put up a fence where his property line actually is, so that he's defending his property now. And then, of course, there was a realtor here that got involved. They even interview her. She acts like she's just like, oh, an innocent party. But she's actually, I think, an instigator here. She lives across the street. And I think she got the listing to try to sell this house, and now she's causing a problem for this guy who's looking to get a variance to build a house on the smaller lot. I think because she was unable to sell this house, she's like, well, look what he did. He put a fence through their pool here. She's causing problems for him. But the guy is doing what he should be doing, protecting his property rights. That's the only way he's going to be able to build a house on this. This is weird, but check it out anyway.
This is a wild story. New from Orlando, there are big questions tonight about what is going to happen to this house in Wadeview Park now that a boundary dispute has reached a whole new level. Check out this new fence. It splits a pool in two. Channel 9 Shannon Butler is live there in downtown Orlando. It's just south of downtown. And Shannon, this fence has neighbors scratching their heads and wondering what will happen next here.
Yeah, if you walk down this street here in Wadeview Park, it looks normal, right? There's a house on this lot. There's no house on this lot. But if you look behind the bushes here, you can see the guy without a house has put a fence on the guy with a house, making it clear where the property lines stand. Now everybody is asking, what's this guy do now? This home along Harding Street sat vacant for years, all because of a boundary dispute. The MLS listing says, quote, the pool and the garage are partially on the adjacent parcel and not included in this sale. Huh? It's such a mess that realtors don't even want to touch it. This realtor posting about it saying, quote, my job as a realtor is to help people buy and sell properties. Sometimes my job is to help people not to buy. So the house was just sold at an auction, and now what was a dispute has been taken one step further. The owner of this lot seemed to have put up a fence right through the pool of the other guy's lot, splitting the garage and that pool in half.
That's where we stand now. We have a brand new owner of this house, and this is how they choose to make their statement to the new owner.
Lisa Sconyers is a realtor and has lived across from the two properties for years. The history is long and sordid, but the easiest way to explain it is that both lots were owned by the same person, a house on each. He then sold them to the new owner, who then cleared the lots to build one big house. But that owner went into foreclosure and the lots were sold to two different people. So now this house is over the property line of the other lot. In the end, Sconyers says this could have all been avoided.
The city of Orlando didn't permit this the right way. What they should have made these people do is they should have made them replat the property into two separate properties. They never did that.
Now, we have reached out to both sides and the city. We're still waiting to hear back. Now, when it comes to this property here, this property owner is trying to get a petition. He's gone around to the neighbors, asking the neighbors to give him an exception to back it up because this lot isn't big enough for a house, to allow a house to be built there. Now the neighbors are saying, I don't know if I can back you on that because you asked us to do that before you did this, and this problem still isn't solved. We're live.
And who was that neighbor? The one across the street, the realtor? You know, he's going around trying to get permission. That permission is a variance. Okay. When a municipality gives a variance, what they require is that the person seeking the variance, which is a permit, to vary from the current zoning laws. In this case, it requires him to have a larger lot to build a house on. He's trying to get a variance so that he could build a house on the smaller lot now. And if that's the case, he'll take down the fence and he's got no problem. But if he can't build a house on the lot that he bought because the neighboring house is halfway on it, he's got he's perfectly right in protecting his property rights there and putting up a fence there. Yeah, the city did a wrong thing to begin with. They should have required, if you were going to tear down both the houses on these lots and then build one larger one that goes over the property line, even though you own both of those properties, they should have been combined into one. So when it was sold at auction, they shouldn't have sold it off as two separate lots. That's where they made the mistake. But now that you got one guy that has a smaller lot, he should be given the variance permit. But he's got to go to before a municipality will issue a variance, you need to send out a letter to everybody that lives within 300 feet of your property. And if anybody brings up an objection to it, then then the municipality won't grant the variance. Okay. I mean, you can argue it in court and stuff, but then it gets long and drawn out. But that seems to be what's going on here. And I think it's the realtor across the street that's causing the problem because she wasn't able to sell this house and it ended up going to auction now, you know? So interesting story though. Ever see that happen before? Fence through the middle of a house?
In Orlando.
Kind of nutty. All right. A party wall is a shared common wall. It's a wall that separates two properties, like with shared housing, like with townhouses or duplexes where you have one unit next to another. That wall that separates the two separate properties is known as a party wall. And each party has an easement rights to the other side's wall because and both are obligated to maintain the wall, because if they don't, the wall comes crumbling down and nobody has a property line, right? These party walls in old days could have been like these stone fences that separate properties, right? The modern party walls are attached housing, that has a wall separating the two units. That's all it is. Okay, so page 111, just to know what a party wall is. It's a wall of a building that straddles the boundary lines between two owners' lots. Okay, each are responsible for maintaining their side of the wall.
So like row houses?
Yeah, as long as they're attached, yes. Row houses, they're basically kind of, they're many it's like a townhouse. A townhouse is multi-level attached housing. Okay, so it's basically the same thing. It's got a common party wall separating the units.
Okay.
All right, so here on this one slide, I have the definition of party wall, what a license is, what an easement is, and what an encroachment is, which we're just getting into now. An encroachment is anything that crosses over the property line, like a part of a building, fence, driveway, or other installation illegally extending beyond the owner's property onto the neighbor's property. And I've had a student in the past that gave me this clever little definition here, so I added it to the slide. The word encroachment has the word roach in it, and much like a roach, it's something you don't want on your property, right? So it's the neighbors, built something that crossed over the property line, like this house, part of the house, or or that one where I showed you from People's Court, where the neighbor built a chicken coop and a shed on the neighbor's property. I've come across instances like this where somebody had a concrete garage that was built on over about 1.5 feet over the property line. And, the lady didn't really want to do nothing about it. And I was like, I really don't want to take this listing until you clear that up. You really shouldn't put the property on the market for sale until you clear up this problem, because it's going to be a problem for any buyer, because they're all going to get a survey. She's like, well, we don't need to tell them about it. I was like, no, we need to. You're required by law. This is material information. And me as a real estate licensee, by law, I'm also required to disclose any information of a material nature to potential buyers. We got to treat them fairly and honestly. And, she didn't want to do that. So I was just like, I'm out. So, I mean, an agent took that listing eventually. I wouldn't have. Not until she cleared up that problem with the neighbor. But they eventually did, and they tore down the garage because it was over the property line. They had the city tear it down. City ordered the neighbor to tear it down. Okay, so how do we create easements? Well, actually, it's lunch, so we'll break for lunch. This chapter is almost done, but we'll break for lunch and we'll finish it after lunch. So let me pause this.
Recording in progress.
All right, so how do we create easements? Well, we could create them by express grant of permission of the property owner to create it, by a deed when they're conveying the property, creating an easement over the sold land, granting the new owner an easement over the grantor's remaining land, long-time usage with an easement by prescription. This is the type of easement that's created by using a property. Now, this is kind of a negative one, though, because you're trying to take someone's property from them. That's what an easement by prescription is, right? Do adverse possession. By necessity, that's for the purpose of ingress or egress for landlocked properties. In order to gain access to your property, it's necessary to cross over someone else's. And an easement in gross. This is a public utility easement. Now, they could ask the owner for permission, or they could just take the land if it's needed using eminent domain because it's needed for the greater public good. course, the owner will be needed to be justly compensated for that. So, I mean, you guys do enjoy that nice, clean, abundant natural gas that goes to your house, that heats your house, that heats your hot water heater, that dries your clothes in the dryer, right? Or do you prefer the oil heat? Or would you rather spend money on electric, you know, that dry heat? See, there's different kinds of heating systems. So you get the people that are against gas and stuff until it affects them in their home. All right. So those pipelines that come from refineries have to cross over people's properties before they get to your house eventually. So easements are necessary for certain things like this. These are easement in gross for public utility easements. Look, all right. There's also something called an easement by implication, but you know, that's hard to get. You need to prove it was somebody's intent to create the easement to get an easement by implication. Good luck with doing that. You know, a court action is needed for that. You would need to prove that it was the owner's intent to create an easement. That's implication, an easement by implication. How do we terminate an easement? Well, when the purpose for the easement no longer exists. It only applies to an easement in gross or utility easements. You know, if the utility company no longer needs that easement, then that's the only type of easement that would cease to exist if it was no longer needed. Okay, so if you ever hear a statement like that, what type of easement would no longer can be terminated when it's no longer needed? That only applies to an easement in gross, the utility easement. Go ahead, Gladys. I'm sorry.
Can you define an easement by itself? Just an easement.
It's a right to use the land of another for a particular purpose.
But not taking it, like it's not yours.
No, well, it's a right. It's a right. It's not ownership. Right?
Okay.
So it's only a right to use. It's a right of use, a right to enter, you know, but it is not ownership. It does not create ownership. So when the owner of the dominant or servient tenement becomes the owner of the other, that could terminate the easement because you don't need an easement to cross over your own land, right? A dominant estate can give up their rights. They could release the easement right to the owner of the servient estate. So they are just giving up their rights. Or once again, abandonment. Abandonment is kind of like the implication. You'd have to prove what the person's intent was. And that's hard to do. Look, my dad, when he was alive, he owned a property in Pennsylvania, had a piece of land there, and always talked about one day moving back to Pennsylvania, you know, because he grew up there, you know. So one day he'll move back to Pennsylvania, you know, but he never did till the day he died. But he always had the intent to. But as far as the neighbors over there to his property are concerned, nobody's been there for years. They've abandoned it. See, you got to look at it from the view of different people. Like the owner, my father, he was always intending to go back there, never did, you know. But in the eyes of the neighbor, it was abandoned. But in the eyes of the court, in order to prove abandonment, you have to prove it doesn't constitute just non-use of the property. You have to prove the intentions of the owner, that they're intending to abandon it. My dad didn't intend to. He always wanted to go back, right? So good luck getting that type of easement or terminating an easement right that way. If he had an easement right, he owned a property there. But let's just say somebody had an easement there. You can't prove abandonment so easy. All right. So once again, license is permission. That's how it differs from an easement. Easement is a right. And when it's established that you have rights, nobody can take them from you. But licenses can be revoked. They can be taken from you. Your license is permission, like your license to drive. It's permission to drive. It can be revoked at any time, right? Encroachments are anything that any installation that illegally extends beyond the boundaries of the property owner onto the neighboring property. So when all are part of a building, fence, driveway, or other installation illegally extends beyond the land of its owner. Boom. That's encroachment. Okay.
Yeah, so for license, it's just a term here, or is there a hard copy for that also, like driving license?
No, license is often
It's just a
verbal.
term.
Yeah,
Okay.
like give the examples that I wrote up here. You know, you're my neighbor, and I say, hey neighbor, feel free to come over, use my pool anytime you like. I just gave you a license to enter my land for specific purpose to use the pool. But if we
Okay,
get into an
permission.
argument, I could revoke it. I could just say, I don't want you on my damn property no more. I just revoked it. It's as simple as that, right?
Okay. Thanks.
You're welcome. Okay. Restrictions placed in deeds are known as restrictive covenants. It's a restrictive legal promise. A covenant is a legal promise. These are restrictions, which are legal promises added to the deeds. Only private parties can place restrictions in deeds, not governments. Restrictive clauses are added to the deed when the property is conveyed. These are established by the seller to restrict the future owner's use of a property. And it runs with the land. Those restrictions pass from one owner to the next unless they put a sunset clause in there that says on the happening of a certain event or in a certain time frame that restriction would go away. All right. That's the only time that those would be removed. The types of estates are based on restrictions are known as fee determinable, defeasible, or conditional fee estate. Okay. Remember that one from, was it the beginning of this chapter or last chapter? So deed restrictions, also known as restrictive covenants. You could write that in your book there on page 112. Are clauses added to the deed when the property is conveyed that establishes the seller to restrict future owners' use of the property. It's also known as fee determinable, defeasible, or conditional fee estate. So there you go. Write those notes down there. Okay. Let's also see how another way that we can remove easement rights.
If you think you fully own your property, you might be surprised to learn that someone else could have the legal right to use part of it. And here's what's even more shocking. If you think you fully own your property, you might be surprised to learn that someone else could have the legal right to use part of it. And here's what's even more shocking. You might have given them that right without even realizing it. I'm Tiffany Weber, real estate attorney in North Carolina at Thomas & Weber. I've done thousands of closings in the Lake Norman area, and easements are one of the most misunderstood aspects of property ownership I see. Today, I'm going to break down exactly how easements are created in North Carolina, and more importantly, how they can be terminated. By the end of this video, you'll know exactly what to look for in your deed and what rights you actually have. If you own property anywhere in the United States, this information is crucial. And if you're in North Carolina specifically, there are some unique aspects you need to know. Let's dive in. I'm going to give you some quick terminology. First up is dominant and servient tenements. The dominant tenement is the land that is benefiting from the easement. The servient tenement is the land that is burdened by the easement. Another way to talk about this is calling them the benefited and the burdened parcels. This will be important for later when we talk about how to get rid of an easement. So let me break this down for you. In my last video, I explained that an easement is a non-possessory right to use someone else's property for a specific purpose. But here's what most people don't understand. There are actually at least 4 different ways an easement can be created. First, there's an express easement. This is the most straightforward one. It's created by a written agreement, usually in a deed or a separate written document. When I'm doing closings, this is what we see most often. The document gets recorded in the Register of Deeds and boom, you've got an easement. Here's what's really happening. Let's say your neighbor needs to cross your property to get to the main road. You sign an easement agreement, it gets recorded, and now they or their successors in interest have that legal right forever, or at least until it's terminated, which we'll get to. Second, we have implied easements. Now, this is where it gets interesting. These are created by the circumstances, not by a written document. In North Carolina, courts may find an implied easement when there's been an apparent and continuous use of the property that's reasonably necessary. For example, I see this a lot with family land. Let's say dad owns 10 acres, he builds a driveway across it, and then splits the land between his 2 kids. Even if the deed doesn't mention the driveway, the kid whose land the driveway crosses probably can't just block it. The court might find an implied easement because it was obviously necessary when the land was divided. Third, there's easement by necessity. This is similar to implied, but it's specifically about property that was once owned commonly, and at the time of the transfer, the easement of whatever kind was necessary to the beneficial use of the land. A good example of this is property that would be landlocked if split and transferred, such that an easement over one property is necessary to be able to use the other property. Fourth, we have prescriptive easements. This is the one that really trips people up. In North Carolina, if someone uses your property openly, continuously, and without your permission, plus a couple other things, for 20 years, they can actually gain an easement right. To become official, this prescriptive easement must be litigated, and that's a claim called quiet title. Let me be really clear about this because I see this confusion all the time. The use has to be hostile. And that doesn't mean you're like fist fighting. It means without permission. If you give your neighbor permission to use your driveway, the clock never starts running for a prescriptive easement. Now here's where it gets really interesting, and this is what a lot of property owners want to know. How do you get rid of an easement? There are actually several ways, and some are easier than others. First is release by the easement holder. This is the simplest way. The parties who have the easement right, usually all of the owners of the benefited parcel, sign a document terminating their rights. It gets recorded in the Register of Deeds and the easement is gone. But here's the thing, you can't force someone to release their easement. They have to agree to it. And the owners of a burdened parcel can't unilaterally terminate an easement. Only the owners of a benefited parcel can do that. Second is expiration. Some easements are created with a specific time limit or condition. I've seen easements that say, for as long as the property is used for agricultural purposes, or for a period of 10 years. When that time is up or the condition changes, the easement automatically terminates. Third, abandonment. Now, this is tricky in North Carolina. Non-use is not enough alone to qualify for abandonment. The easement holder has to show a clear intent to abandon the easement. I've seen cases where an easement wasn't used for 20 years, but because there was no clear intent to abandon it, it was still valid. Here's what you need to understand. North Carolina courts require clear and convincing evidence of intent to abandon. Simply not using the easement isn't enough. There needs to be some affirmative act showing they're giving it up.
Same in New Jersey. All this stuff so far that she said applies in New Jersey as well.
Fourth is merger. This happens when the same person ends up owning both properties, meaning the one burdened by the easement and the one benefiting from it. When that happens, the easement merges into full ownership and disappears. I see this sometimes when people buy neighboring properties. There's a case, the caption I can't exactly remember, but it states, it is axiomatic in property law that one cannot have an easement over his own property. That's because you don't need one. You own the property. Fifth is necessity. And just like you can gain an easement by necessity, you can lose one too. So if the reason for needing the easement no longer exists, the easement may potentially be extinguished. But you've got to be careful here. Blocking an easement can lead to lawsuits. Sixth, there is eminent domain or foreclosure. If the government takes your property through eminent domain, some easements may be extinguished. Same thing with certain foreclosure situations, though this gets pretty complicated and depends on when the easement was created versus when the mortgage was recorded. So what does this mean for you? Here's what I tell all my clients. First, always get a title search when you're buying property. This will reveal any recorded easements. But remember, it won't show you prescriptive easements or implied easements that haven't been litigated yet, or any easements that maybe were just verbal or talked about between parties. Second, if you're giving someone permission to use your property, get a lawyer, put it in writing, and make it clear whether you are giving revocable permission or an easement. I can't stress this enough. Informal arrangements can turn into legal nightmares. Third, if you have an easement you don't want anymore, don't just assume it'll go away. take action. Whether that's negotiating a release or determining if the easement has been abandoned, you need to be proactive. You may not be successful, but you certainly won't get anywhere just sitting and hoping. Let's recap what we covered. Easements can be created at least 4 ways: express, implied, necessity, and prescription. They can be terminated through release, expiration, abandonment, merger, necessity, eminent domain, or foreclosure. In North Carolina, prescriptive easements require 20 years of hostile use among other elements, and always.
In New Jersey, how long does it require?
30 years.
If it's improved land and unimproved woodlands?
60 years.
There you go.
Always put easements in writing to avoid creating a legal mess for yourself later. The bottom line is this: easements are powerful property rights. They can significantly affect your property value and use. But wait, there's one critical thing about easements I haven't told you yet. What happens when your neighbor's easement is damaging your property value by thousands of dollars, or when you discover an easement on your property that nobody told you about? I covered exactly this in my last video about easements, including the one type of easement that can completely destroy your property rights without you even knowing it exists. It's this video right here. If you think you fully own your property,
All right,
you
well,
might be surprised.
We don't know what video that was that she was referring to, so we'll stop that. I snagged it for YouTube. Okay. Well, let me see. There was 2 other ones about easements she has that one about red flags and one about the difference between an easement and a right of way.
Aren't they just the same thing? Not exactly. Today we're going to dive into that. I'm Tiffany Weber. I'm a real estate attorney, and since 2020, we've done almost 10,000 closings in our office. So we've seen plenty of easements, plenty of rights of way, and we will break them down for you today. I know it's super confusing when you hear the term easement and right of way used interchangeably. And here is a simple way to remember the difference. Maybe not that simple, but all rights of way are easements, but not all easements are rights of way. A really simple explanation of this is an easement is general. That is the right of someone else to use your property, sometimes for a specific purpose, sometimes for a specific length of time. And a right of way is a type of easement. It gives someone else the right to use your property, but right of way specifically refers to the right to pass over property, like travel, to drive, to walk, etc. There are all kinds of easements. So, for example, a road. If you have a big farm property and you have a road running through it, that's a right of way. That gives people the right to pass over your property to get from point A to point B. However, on that farm property, you may have all kinds of other easements. You most likely, if you've got electricity, you have a utility easement, and that is the right for the utility company to come in and install, maintain, inspect, etc., the utilities.
And what's that called?
Easement apartment.
Gross.
In gross. An easement in gross is the utility easement.
That is not a right of way. They're not going from point A to point B. This is not about travel. This is about getting to use a certain portion of the property for that purpose. Another example of an easement that you may have is for a shared well. So you may have a well that's right on the property line between 2 properties, and you're agreeing that you can share it with the other property owner, and you each get to go on the other side of the property for the purposes of using the well, maintaining it, inspecting it, etc. However, that's not a right of way. That doesn't give your neighbor the right to drive across your property to go somewhere. Easements are extremely common. Almost every property that you see has an easement on it of some kind. Specifically, if you're going to have utilities, it's near impossible to get utilities to your property without also granting a utility easement. A right-of-way is a lot less common, though you still see them quite often because people do have to drive and walk, etc., to get to other pieces of property. So you might see a right-of-way on your property if there is a landlocked parcel behind you. It was probably granted long before you ever came on the scene to allow whoever is landlocked to get over your land to be able to get to a public right-of-way. And how do you find out what kind of easements or rights-of-way affect your property? The answer to that is by doing a title search. And you usually hire an attorney to do that, though there are all kinds of companies that do title abstracts. You're going to see all kinds of reference, old, new documents that explain the easements, the terms, how long they last, who has the right to do what. Now, regardless of whether what you have across your property is an easement or a right-of-way, it's important that you know about it before closing. You can do that by looking at your plat if your property is platted. Example, most neighborhoods have this, and you'll be able to see the marks on the plat showing where the utility easements and other easements are located. If you are buying a rural property, then it's a really good idea to get the property surveyed. Any property, by the way, get the property surveyed, but especially if it's rural and you need to locate where any easements are on the ground, because it might affect your plans for the property. The key takeaway is that all rights-of-way are easements. Not all easements are rights-of-way. Easement is a broad category. A right-of-way is a type of easement. Easements and title are just one aspect of what a real estate attorney does and how your closing takes shape. We've made a lot of videos on this process, and YouTube thinks that you should watch this one right here. You're reviewing the title.
All right. I don't know which one that was either because it didn't pop up because we're not watching it on YouTube. All right. Now she has one more here. I don't know if this, I forget what it was about, but I saved it for some reason. It is a 4 easement red flags home buyers should never ignore. Let's take a look. Oh. Hold on. Where's my Zoom control so I could share it with you? That's where do you go, Zoom? Okay, here you go. Sorry about that. See, these videos aren't too bad, right? Even though she's from North Carolina, you know, a lot of these things apply to us too. You know, so I think she explains them in a pretty good way, and then me stopping it and chiming in every now and then. It's not bad explanation here, and you're getting these explanations from a lawyer.
Found the perfect house. Great neighborhood, great price, great lot. You're ready to make an offer. But you look in the property documents and see there's an easement. And if you ignore it, it could cost you thousands of dollars and a whole lot of headaches after you close. I'm Tiffany Weber, real estate attorney in North Carolina at Thomas & Weber. I've done thousands of closings in the Lake Norman area, and I want to walk you through 4 easement red flags that every home buyer needs to know before they sign anything. By the end of this video, you'll know exactly what to look for, what questions to ask, and what could turn your dream property into a nightmare if you're not paying attention. Let's get into it. Red flag number 1, shared well agreement. The first red flag is a shared well agreement. Here's what most people don't realize. If a property has a shared well, that well is physically sitting on someone's land. Maybe yours, maybe your neighbor's, and that matters a lot. You need to find out which property actually has the well on it. Do you have the legal right to access it? Who is responsible for maintenance when something breaks? And wells do break. And is there a monthly surcharge for water usage? I've seen buyers fall in love with a property, close on it, and then get hit with unexpected maintenance costs they had no idea they were responsible for. Read that agreement carefully before you close. Red flag number 2, shared driveway agreement. The second red flag is a shared driveway agreement. This one trips people up because they see a nice long driveway and assume it's all theirs. But if there's a shared driveway easement, you need to understand exactly how that driveway works. Who maintains it? Who pays when it needs to be repaved? How many other properties are sharing it with you? And critically, does anyone have the right to block it? Because if your neighbor parks across that driveway and you can't get out, you need to know ahead of time what your legal options are. These agreements can be very reasonable, or they can be a constant source of conflict. Know what you're getting into. Red flag number 3, lake access easement. The third red flag is one that comes up a lot here in Lake Norman specifically, and these are lake access easements. When a lot of these neighborhoods on the lake were developed, the off-water lots were given the right to reach the water by crossing over the waterfront lots or through a designated access lot. That sounds fine on paper, but here's what you need to know if you're buying waterfront property. People may have the legal right to cross your land to get to the lake. You need to know who has that right, when they can use it, and whether the current use is within the scope of what the easement actually allows. Easements can be overused, and if they are, you have options, but only if you know what the scope is supposed to be in the first place. Red flag number 4, encroachment agreement. The fourth red flag is an encroachment agreement, which is actually a form of easement. An encroachment agreement allows someone to put something on property they don't own. It could be a fence, a shed, part of a structure, either for a set period of time or permanently, depending on the terms. So here's what you need to ask. Is it your stuff that's on someone else's property? If so, when might you be required to remove it? Or is it someone else's structure sitting on your land? Do you have to allow it to stay forever? Are they required to maintain it? These details matter a lot. The bottom line is this. Easements are not automatically a deal breaker, but going into a closing ignoring what's on that property, that's how buyers end up with problems they didn't see coming. Review your survey. Read every agreement and document you're provided by the listing agent. And if something doesn't make sense, ask your real estate attorney before you close, not after. So there you have it. 4 easement red flags every home buyer needs to look for before they close. Shared well agreements, shared driveway agreements, lake access easements, and encroachment agreements. You take the time to review these before you sign anything, even the offer to purchase. You're going to walk into that closing with confidence, knowing exactly what you own, what you're responsible for, and what rights other people have on your property. That's the difference between a smooth closing and a very expensive surprise. And if you want to go even deeper on easements, how they're actually created, how they can be removed, and what your options are if one is being misused,
Watch this video.
Watch this video right here. It covers
I saw that one coming a mile away. Watch this video. All right. So actually, all 3 of those videos weren't bad. They were related to this class and this chapter. So there you go. I don't regret showing them. Okay. So the deed restrictions. You guys have all those notes down. Restrictions placed in deeds by private parties, not by government, and deeds that have restrictions in them are called fee determinable or defeasible fee or a conditional fee estate. Those 3 names describe the same type of estate that's based on a restriction that we went over at the beginning of this chapter on page 104. Okay. That concludes this chapter 6. Let's get to the key terms to review. The best part, the game show part of this chapter that you guys all love to answer, the Q&As, right? You like to get involved in your learning process. There are actually 2 long key terms to review in this chapter. Before we do them, let's go to key terms number 1 for chapter 6 and cross out the word indefinitely next to A, the letter A. Cross out the word indefinitely and write forever or a lifetime. You're crossing out the word indefinitely next to key terms 1, letter A, and then writing forever or a lifetime in its place. Then go to letter E, as in Edward, where it says ownership as long as, right after that, based on a restriction. So that term as long as is usually referencing as long as the restriction is not violated, okay? So right, based on a restriction after as long as next to letter E. And the letter right beneath it, F. It says amount of ownership. Let's cross out the word ownership and write or kind of interest in real property. Or kind of interest in real property. So it reads amount or kind of interest in real property. And those are all the modifications for the first key term to review. We could go over to the right, to the next page for key terms to review 2. Next to letter D, cross out the word lien and write legal action and put in brackets foreclosure. So it says, notice that a legal action foreclosure may be filed. Then go to letter J, cross out the word will and write may above it. Instead of will, write may. Then go to letter L in key terms 2 and try to write above the first word because it's supposed to be like in front of there. Instead of where it says future interest of an owner, write the word possible above that. So it reads possible future interest of an owner. And that's all the modifications we'll need to make here. Everybody good with the modifications and we could get started, or? Okay. So key terms 1, chapter 6, ownership lasting forever or a lifetime. What are we describing?
Is it freehold estate?
It would be freehold estate. 16 is A. Permanent right to use another's land.
Easement.
Correct. 6 is B. There's not enough information to know what kind of easement, so it's simply an easement. Correct. 6 is B. Husband's right in the wife's property.
Courtesy.
Courtesy, because men are courteous to women, so that is the husband's right. 3 is C. Simple right to use part of an adjacent parcel.
Dominant estate?
Apartment.
Easement appurtenance. Easement appurtenance. 7 is D.
Tenant.
Remember, for appurtenant to exist, you have to have 2 adjacent parcels with a dominant estate and a servient estate. So this is the simple right to use part of an adjacent parcel is known as an easement appurtenant. Now, the person that's trying to use that parcel is the dominant estate. Correct. But this was asking which type of right. So that would be the easement appurtenant. Easement is the right. So 7 is D. Ownership as long as based on a restriction.
Divisible fee or conditional fee. Fee determinable.
Yes, all of those. Yes. So a fee determinable, defeasible, or conditional fee estate would be correct. 14 is E as in Edward. Amount or kind of interest in real property. Amount or kind of interest in real property.
Easement in gross?
That's utility line, no?
Yeah.
Is it amount of interest?
The amount or kind of interest one has in real property is known as?
Is it encumbrance? No.
An
It's not
estate in
construction.
land. It's an estate in land.
Which one's
That's
that
actually,
one? Oh,
that's the definition for estate in land. It describes the amount or kind of interest that one has in real property. And then there's 2 categories of estate, the ownership, which is freehold, or the leasehold estate, right? Which is less than freehold. You're not free to hold it forever or a lifetime. So 13 is F. The right to use utility lines on another's land.
This is gross.
C.
Easement in gross.
Easement in gross.
Easement in gross. 10 is G, easement in gross. A right of access to a landlocked parcel.
Uh,
How do you get to your property when it's surrounded by other people's property? What gives you that right?
by necessity.
Necessity.
Yes, because it's necessary. 8 is H, easement by necessity. A wife's right in her husband's property.
Dower.
5 is I, dower. Because you remember that? Dower begins with a doe, and a doe is a deer, female deer. So that's the wife's rights. 5 is I. A right sometimes acquired through usage. What kind of right
By
do you acquire?
prescription?
Yes, by prescription. 9 is J. An easement by prescription. Transfer by sale or gift.
Convey.
Yes, 2 is K. Property that benefits from an easement.
Dominant.
That's the dominant estate. 4 is L. The most complete ownership of land possible. Unrestricted
Fee
ownership.
simple. Fee simple. Fee
It's
simple.
fee simple or fee simple absolute is correct. 15 is M, as in Michael. Mary. Any easement, encroachment, etc. They are all
Encumbrances.
they're all encumbrances. 12 is N, as in Nancy. Placed against real estate by a worker who has not been paid.
A construction lien.
Correct. 1 is O, a construction lien, also known as a mechanics lien, right? 1 is O. Building intruding on another's land because it crosses over the property line.
Encroachment.
An encroachment is correct. 11 is P, as in Paul. All right, that concludes key terms 1. Everybody got those? Anybody miss anything? They need anything? Good. Okay. Key terms 2. Structure owned by 2 adjoining landowners.
Party wall.
Correct. It divides the properties. Correct. The party wall. 9 is A. A claim against all property someone owns. Claim against all property someone owns.
General lien.
General lien.
1 is B. That would be a general lien. That is correct. A claim against one parcel of real estate only.
A lien. Oh, specific lien.
A specific lien. I was just about to tell you. Can you be more specific? 14 is C. All right. A notice that a legal action.
Wait a minute.
Sorry.
14 is C.
C. 14 is C.
Oh, 14 is C, not D.
Yeah, C as in cash.
Car.
There we go.
Yeah.
Car. Notice that a legal action being foreclosure may be filed.
That's going to be lis pendens.
Lis pendens is correct. 7 is D as in David. Lender's claim against real estate.
Involuntary lien.
A lender's claim against real estate. Lender's
mortgage lien.
A mortgage lien. 8 is E as in Edward. Temporary permission.
License.
4 is F as in Frank. Right to use and possess for a limited time.
Leasehold estate.
A leasehold estate. 3 is G. Property taxes are 1.
Property taxes.
Priority.
No.
Involuntary lien.
It's a lien?
Yes. 2 is H, involuntary lien. Who wants to pay those, right? But we still got to. So 2 is H, involuntary lien. The order in which liens are paid. What determines the order in which liens are paid?
Priority.
Their priority. 10 is I. Third party who may gain eventual ownership.
Reminderman.
A remainder man. 11 is J, as in Jack.
Thank you, Yaya.
The tract over which an easement runs. The tract over which an easement runs.
Servian. What was?
Yes.
Servient
Yes.
estate.
Just say servant, right? Servient or servant estate. Correct. 13 is K. Possible future interest of an owner.
Life estate.
Possible future interest of an owner. Possible.
Revisionary interest.
A reversionary interest. 12 is L. It's possible that the ownership can revert back to a previous owner if you violate the terms of the sale. So it's called a reversionary interest. 12 is L.
Oh, wait a minute. I just thought of a way. So it could go back to the owner. So reverse.
If you violate the terms of the sale, reversionary, reverse. The property reverts back to the previous owners.
Got it. Thank you.
You're welcome. Adding successive periods of usage.
Tacking.
You tack on one person's time to another to get easement by prescription, right? To reach that prescriptive period. 15 is M, as in Mary. Complete ownership until someone's death.
Life estate.
6 is N, as in Nancy, the life estate. A financial claim against real estate.
Lien.
That's a lien. That's a definition of a lien. 5 is O. A mortgage or equity loan, for example.
A voluntary lien.
Yes, a voluntary lien. You went out of your way to get it. 16 is P as in Paul. And that concludes chapter 6.
Hey.
All right.
Cooking with hot